Yes.
Yes, please, your lordship. My lord, back to mention item number 54 and 55, my lord. Arising of the case diary, same case diary, my lord, but case diary has not been received, my lord. I have been informed, my lord.
54, 55. In case they are not received, huh? Let the matter be listed.
Interim, sir, interim.
When? Third of August. Third of August.
Interim order may continue.
Interim order superstar shall continue.
Oblige, my lord.
May I please your lordship?
Hmm.
Well, I beg to mention item 46, my lord. Here also, my lord, case diary not received, my lord.
Court note case diary not received. Let the matter be listed on 4th of August.
And interim may be continued.
Interim order superstar shall continue.
May I please, your lordship? Lordship, with consent of the other side, I beg to mention item number 26, lordship. Lordship, matter may be taken after 1 week, lordship.
Okay, on the prayer of the learned counsel, appearing for the petitioner, let the matter be
Not for
listed.
the petitioner.
I'm respondent.
Respond.
Respondent. On the prayer of the learned counsel, appearing for the respondent, which is not objected by the counsel appearing for the petitioner, let the matter be listed on 5th of August. 5th of August.
Yeah.
Lordship, item number 23, lord.
Hmm?
23, lord.
20?
23, 23.
2, 3, yes.
Lordship, adjournment for today, lordship, I will inform the other side, lordship. Lordship, matrimonial dispute, lordship, maintenance. Already the petitioner is paying.
You have spoken to other side. Huh?
Lordship.
You have spoken to other side, consent.
I will inform, lordship, but otherwise, lordship, there is discussion is going on for settlement.
You are appearing for,
Petition.
Mr. F. Hogg, learned counsel, appearing for the petitioner, praise for adjournment of the matter. Praise for adjournment of the matter due to the fact that some talks are going on between the parties. Talks are going between the parties. Let the matter be listed in the 2nd week of August.
May I please, say, if I take mention item was 64, my lord. From the orders column, my lord.
Hmm?
It's a cancellation of bail filed by the state, my lord.
Hmm.
So can it be after some, after a week, my lord?
State. Mr. D. Vora, learned counsel, appearing for the respondent. Respondent, praise for adjournment of the matter and the same to be listed in the 1st week of August. First week of August, which is not objected by the council appearing for the state. Let the matter be listed in the 1st week of August.
Obliged, man.
May I please, the lordship, for item number 12, I may allow to withdraw this petition, lordship.
Okay, your name?
M. Bhuyan, lordship.
MSIM Bhuyan, the learned counsel, appearing for the accused applicant, submits that she has instructions to withdraw the instant case. It's an AB application. AB application is dismissed on withdrawal.
Lordship, also I beg to mention item 60 for
Hmm?
adjournment. Item 60.
60.
Yes, lordship.
Hmm.
Conducting counsel M. Alam is out of station.
Who?
M. Alam.
Okay, on the prayer of the learned counsel, appearing for the accused applicant, let the matter be listed in the 1st week of August.
Lordship, there is an interim order that may come.
Let it be listed on 3rd of August. Interim order. CD is received. Then it may be on 23rd of July.
27, can be possible for the day.
Which matter?
27.
27.
Then case advocate out of station.
Okay, on the prayer of the learned counsel, appearing for the petitioner, let the matter be adjourned for the day and to be listed on 1st week of August. To be listed on 1st week of August, and a date to be fixed by the registry.
My lord, I have a prayer in item number 50, my lord.
50.
Yes, that was listed on the last week, my lord.
You have got the
Possibly
file?
please to, my lord, yes.
Ah.
Everything is ready, my lord. The
Ah.
file has been recreated, my lord.
Ah.
Matter may kindly be taken at 2 p.m., my lord. Because
No,
it's,
will
my
be
lord, item
taken
50.
by as per this thing, I mean, as per
No,
the,
but I have a prayer for upgradation, my lord.
no upgradation. We'll take it up when there's not much matter, it will be taken up, I mean, don't worry, it will not be left out.
Fine.
I mean, always we are finishing the list.
Yes.
It's not that we are not finishing the list. You taken up.
Indeed.
Huh? Item number 20, yes. Huh? Okay, okay. Item number 20, on the prayer of the learned council. Your name is just, and the learned council, D. Hazrika, let the matter be listed. Item number 20. Okay, let the matter be listed, listed on 3rd of July. Sorry, 3rd of August. 3rd of August. Yes.
Your Lordship. Lordship, I beg to mention item number 67, last item, Lordship.
Hmm.
Lordship, in the last mediation session on the mutual settlement has been made, just agreement is awaited, Lordship. So it may be passed over for the day and fixed.
Okay, item number 67, you read, your name?
P. Bhattacharya on behalf of B. Purkayastha.
B.
P. Bhattacharya.
B. Bhattacharya, on behalf of Mr. B. Purkayastha, submits that, some out of court, some, the matter has, matter, just write the praise for adjournment of the matter and let the matter be listed in the next week. Next week?
No, Lordship, a long time, 2 months, Lordship.
2 months, why 2 months?
Lordship, agreement is needed to be made.
Huh? 2 months, no, I mean, it cannot be granted, I mean, adjournment for 2 months, 3 months, something like that. It may maximum 15 days. What, you have mediation, if it is settled, then only, how much time you take? Let the matter be listed in the list,
15 days, Lordship.
let the matter be listed on 18th August, 18th August.
Lordship, actually, agreement will be made in the next mediation session. Next one date has been given.
So,
Then agreement will
When
be
is the
made.
next mediation session?
It is around 1 month.
Hmm?
It is around, will be nearly 1 month, Lordship.
1 month.
Lord.
Why mediation center is taking so much of time? They're giving. Okay, you write in the last week of August. Last week of August, as some mediation process is going on, just write it. As some mediation process is going on. If it is reaches, then you see the status, then you can mention it. Otherwise, no
Deeply
problem.
obliged, Lordship.
Item 20, yes, what happened? Okay, 4th, make it 4th.
It's a Lordship. Lordship, I beg to mention for listing of a bail application, Lordship may take it up on tomorrow.
Material is to which, what act?
Petroleum and Minerals Act, 2011.
Why today? What is the, is it tomorrow? Tomorrow we'll take it.
Obliged.
Tomorrow, yes, please.
Wait, please, your lordship, in item number 16,
Hmm?
affidavit, item number 16.
16?
16, 1/6,
Ah.
affidavit in reply has been filed, kindly that may be called for in requisition.
What affidavit?
Affidavit in reply, your lordship,
16?
1/6, your lordship. Kindly may be called as.
What affidavit in reply? Bail, AB application?
POCSO matter, the respondents have appeared before this court.
So to provide, I mean, reply, AB application,
Lordship, both the husband and wife, some stranger filed a case and that is pending,
okay.
deeply. Your lordship.
There are listing for Uddo Lordship. Criminal petition Lordship.
Which one? Item number?
Tomorrow Lordship. Tomorrow.
What?
Uddo. Uddo.
You have filed a withdrawal application?
No, yes.
Huh?
Yes. This
Okay.
is pending Lordship.
Hmm?
Like that is 27, 29.
You want to withdraw the matter?
Yes.
You have already filed an application?
Yes.
Okay, tomorrow.
Obliged.
Make please, lordship.
Yes.
It's a regular bail application matter.
Hmm.
Lordship may kindly have a look at page 15 matter. The lordship may tell this FIR matter, earlier matter.
Page 15?
Page 15 matter.
Yes, what is there?
The brief of the case is so and so matter, lodged an FIR matter.
Hmm.
They had a love relationship matter. Then the lady, the informant is aged about 32 years, my lord, and the petitioner is 28 years old, my lord. So they developed a relationship, my lord. Somehow it ended up in, my lord, broken, my lord. Now he is behind the bars for, my lord, last 14 days, my lord.
So we'll call for the same. Heard Mr. N.J. Dutta, learned counsel appearing for the accused applicant, also heard Mr. K.K. Parasar, learned APE for the said, then this is an application, call for CD, let the matter be fixed on 3rd of July, 3rd of August.
Can it be a little bit earlier, my lord? Can it be on my lord?
29?
29.
29th, okay, 29,
I am obliged.
29 July.
For 83 application manner, allegation is of immoral traffic manner. The boy is a handicapped boy. But
Immoral trafficking,
Yes,
so we'll call for the CD.
yes. But one thing is to be and certain. Investigate, as repeat, the investigation was done by the, one was by, not by special officer.
That they will get,
Yes,
they will get.
special,
instruction.
or if
They'll-
it is trafficking police officer, he must.
I
be-
know, that they will get instructions. Heard Mr. S.C. Biswas, the learned counsel, appearing for the applicant, also heard K.K. Parasar, it is an application. Then you write, call for CD, stop, then like the.
3rd of August. madam.
But I will
Learned APP shall also obtain the instruction whether the police officer involved in investigation of the case has been specially appointed by the state government or not. Under the immoral traffic, what is the name of the act?
Immoral Traffic Prevention Act. madam.
Immoral Traffic Prevention
Act.
Act. Immoral Traffic Prevention Act, which year is this?
1956.
1956, Immoral Traffic
But
Traffic Prevention Act 1956.
I will answer
Let the
that.
matter be listed
I will
on.
inform that the accused is seriously ill inside the jail.
Okay,
Jail
the
report may be called from it.
correct, huh?
Jail report,
Jail, the medical,
medical report.
okay, medical report of the accused applicant to be also
Obliged.
published. Huh? Let the matter be listed on, sir, when?
3rd of August.
3rd of August.
Regular bail application, my lord. Page number is 10 FIR, my lord. So allegation of, my lord, the police intercepted one vehicle,
Allegation of what?
the police intercepted on, receiving information, my lord,
Allegation of what? You just tell me what is the allegation. I mean,
thief of cattle, my lord.
call for the CD.
My lord,
Heard Mr.
60
So-and-so.
days is,
The
today
an-
is 60 days, my lord. Today is 60 days,
Today 60 days.
lordship. Other request has been granted by lordship.
Then I'll take
Page
instruction.
number
madam.
24. Page number.
I'll take a telephone instruction, at 2 madam.
Okay, let him take instructions, then we'll take it. Before they are doing anything, you tell that if it's 60 days, if it is 59 days, first thing you say that. Okay.
Right, please, of course. Page 17 is the FIR, my lord, regular bail application. I was arrested on 8/7/26, my lord. Today is 12 days. Games and betting, my lord.
Okay, we'll call for the city hard.
My lord.
Mr. A. Stapada, the learned counsel, appearing for the
Yes,
accused.
where-
So her AK Parasar, and this in application, call for the CD, let the matter fixed on 4th of July, 4th of August.
My lord, punishment is 3 years. Is it possible?
It will take some time to get this in.
From
Hattigaon, my lord.
Hattigaon. Okay,
29,
28
28
to
July.
8.
I'm deeply obliged.
This case under POCSO Act.
POCSO will issue no notice, ठीक है? Heard Mr. ABT Hawk. ABT Hawk, the learned counsel, appearing for the accused applicant, also Parasar. APP, then there is an application, then you will write issue notice. Issue notice to the respondents. Issue notice to the respondent number 2 by Gauhati High Court, duly notification. Then notice to respondent number 1 is dispensed with. Then you write, call for the CD. let
Malas,
us-
scan TCR, malas, Sasid.
Oh, Sasid done. Registry to call for the scan copy of the TCR relating to special POCSO case number 18/2025. From the court of, where is it? Is it been pending?
Special Judge Vishwanath.
Huh?
Special Judge Vishwanath.
From the special judge POCSO Vishwanath. Let the matter be listed on. On 11th of August. 11th August.
Item 6.
May I plead, your lordship? FIR is on page number 12. Operating part is on page number 16. I am behind the bar for last 45 days. May I read the FIR? May I read, your lordship?
What is the offense?
Offense is under section 329, subsection 4, 189, subsection 2, 117, subsection 2, 118, subsection 2, 109, 304.
108(2) and 109 is there, my lord. And
Yes.
this is CD and injury report is required.
As most importantly, may I go through the FIR?
We'll call for the CD in this matter. Heard, heard, Mr.
Already co-accused has been granted bail.
Maybe we have heard Mr.
Are they?
R.D. the learned counsel appearing for the accused.
Short date have given.
Accused applicant also heard Mr. K.K. Parasu in a DP for the said, this is an application under so and so. Call for the CD, let the matter be fixed on 28. 28 co-accused already granted bail. So we'll take it up on 28.
Obliged.
Parasu, is it okay? 28.
Obliged, your lordship.
Anticipatory bail, my lord, FIR is at page 8, my lord.
Page?
Page 8, my lord, annexure 1, my lord. The offense is relating sharing some photos of his girlfriend, my lord. But the accused person, my lord,
Okay, we'll call for the CD.
my lord, may I submit one thing, my lord, only for the consideration of interim prayer, my lord. The accused person was arrested in Kolkata when he was with his father, my lord. Now his, as right ordered dated 30/6/2006 of the Kolkata court, my lord, his transit remand was refused. Rejected, my lord.
Rejected, yeah.
Rejected, my lord.
Mhm.
Therefore, I may pray that, my lord, his interim prayer may be considered, my lord. Already he has been granted bill while rejecting the transit remand, my lord. That is, that order is at page 19, my lord.
Page?
19, my lord. And moreover, my lord, his laptop and mobile has been seized, my lord. So custodial interrogation, in my humble submission, is not required, my lord, as of now, my lord. He may, if he is ready to appear before the trial court and IOA whenever he is called for, my lord. He is student, my lord.
POCSO 6 is there, my lord, that, my lord. Issuing notice, my lord, is difficult. POCSO 6.
You will
Till
say,
then, my lord, he may be protected, my lord. Till the next date, my lord. he
no,
may
no,
be
no, no, no protection. Heard, Mr.
protected. Short date may be.
Heard, Mr.
He Sundi, my lord.
P. Sundi, the learned counsel appearing for the accused applicant, also heard Mr. K.K. Parasar, learned AVP, there is an application under so and so, same, the POCSO thing. So issue notice. Then you call for the CD. Notice to respondent, one is dispensed with, 2 issue notice through Gauhati High Court. Then call for the CD, the later matter is fixed on. Notice will not be served, but we can see about this thing.
29?
29 will be able to do it. Okay, 29 will.
My
My lord.
my lord.
Item 8.
May it please your lordship, I'm appearing for the senior advocate, Mr. T.J. Mahanta. He is currently on legs in court number 1.
Okay, pass over for a time being.
9.
Kindly, madam, you pass over for the time being.
Why?
Because I don't have file, just 10 minutes or 15 minutes.
You don't have file.
Due to rain, I forget my file, that's why just
Okay.
on the way.
Time being.
And then
Your lordship, the matter may be adjourned for the time being, your lordship.
Why?
My senior is in legs, your lordship.
Who is your senior?
S. Mukhtar.
He was here sometime back.
Yes, your lordship. He's in port number 18.
Passed out what time being.
Your lordship, for review application, the FIR is at page 11, my lord. The case is registered under section 115, subsection 2, 118, subsection 2, 189, subsection 3 and 329, 1. Yeah, all sections are bailable except
1182 is there, my
it is
lord.
not bailable. There is a land dispute between the parties,
Injury report is required, my lord.
between the parties and different sellers are annexed here.
Causing severe bodily injury, my lord. Injury without injury is difficult, my lord.
All sections are very land dispute.
Land dispute doesn't mean that you will go and like, you will go and try to kill somebody, madam. Land dispute or whatever, dispute it may be. That cannot be a ground. We'll call for the CD, madam, in this matter.
31st July, my lord. This tarikh.
Okay, heard. Your name, please?
G. Kakoti Das.
G. Kakoti Das, the learned counsel appearing for the accused applicants. Also heard Mr. K.K. Parasar, learned APE for the state. This is an, the right is an anticipated application, so and so, so and so. Then you right call for the CD.
My lord, yes, sir, on 30th of July, 30.
30?
Well.
Okay, 30th of July.
13.
Possible. Time being, what is there?
14.
I mean, affair is to 13 million. Affair incident took place on 4/1/2021 million. And affair was lodged on 24/5/2026. Under section POCSO related.
Where is the affair?
Page 13.
Huh?
Page 13, 1 thing.
13.
At that time, Miller petitioner was underage Miller, 17 years to 1 month.
So we'll have to issue notice. We'll call for the CD.
As
Heard
per
Mr.
FR,
A.
15 years.
Martin, huh?
As per FR, she is 15 years old, my lord.
And boy was Miller 17 years. A birth certificate page 37.
That will be considered. We'll see the CD, then see POCSO is involved and the girl is small and you have allegedly exploited her for a long time.
Yeah.
Heard Mr. A. Martin, the learned counsel appearing for the accused applicant. Also heard Mr. K.K. Parasar, this is an application. Then POCSO matter will be notice to two as per Gauhati High Court, one dispensed with. And then call for the CD. Let the matter be fixed on. When, Mr. Police?
Morrigaon 31st. Notice has to be served.
Okay, 31st of July. 31st of July.
15 Miller out of time affair Miller petitioner is the mother and brother of the main accused Miller.
Okay, same order you pass.
Some protection Miller. Here is the mother Miller.
Let it come.
Mother can protect. Mother and brother Miller, they have no any rule Miller. Kindly see affair.
Father and brother. Mother and brother. Mother and brother.
Yeah, elder brother and mother. They have no any rule Miller in this case. Page 13.
Only at page 14, my lord, encourage the relationship, treated the family as a family, as a daughter-in-law. This was.
Okay, we'll pass, we'll give an interim protection, then let it come, then if there are some materials and otherwise also this is, I mean, no POXO is there, I mean, they are not involved. Against them, nothing is there. So we'll give them some interim protection. Heard Mr. A. Motin, the London Council, appearing for the accused applicants, also heard Mr. K. K. Parasar, and APV for the state. This is an application under so and so. Then a fire was lodged by the informant. Alleging. Who has lost the affair?
Victim Miller.
Victim herself, now she is measured.
Lost the affair by the informant.
Now she is Miller.
Informant alleging that on the promise of marriage, the accused, the accused person, number one. Accused number one is Anwar Hussain Chaudhary. He is the main
He's the
person.
main, earlier case.
Anwar.
Okay. Accused person and the accused person number one on the promise of marriage had sexual relationship with her when the informant victim was a minor, and the issue, the actual sexual exploitation went on from the year 2021 till date. The accused till date, on receipt of the FIR, the police registered Morigaon PS case number 77/2026 under the aforementioned sections. The Learned Counsel appearing for the accused applicant submits that the accused applicant number one is the elder brother of the accused number one named in the FIR, and accused applicant number three is the mother of accused number one and accused number two named in the FIR. He submits that there is no allegations as such against the accused applicants, and they are not involved in commission of any offense as alleged in the FIR. He further submits that he submits that at this stage, some protection should be granted to him. Taking into account the submissions made and after perusal of the FIR, this court directs that in the event of arrest of the accused applicants, the accused applicants shall be released on interim pre-arrest bail on furnishing of bail bond of rupees 30,000 each to the satisfaction of the arresting authority, subject to the conditions that the accused applicants shall appear before the investigating officer within a period of 7 days from passing of this order. Then accused applicants shall make themselves available as and when called for by the investigation officer. Then you write next paragraph. Call for the CD. Issue notice to respondents. Notice to respondent number two by that in terms of the Gauhati High Court notification. Respondent number one, formal notice to respondent number one is dispensed with. Then you write call for the CD.
31st of July.
Let the matter be listed on 31st of July. See, I mean, in between, if you do this kind of, this is not acceptable. Please don't do it. Wait for your turn, then wait for a turn. But you'll have to be patient. If you miss the matter, you'll have to be a little bit patient. And please don't make mentions when the matters are being taken up. Okay. And if there is something which is so urgent, compelling reasons are there, then you please mention. But otherwise, you don't please make this kind of mentions.
After the motion, sir.
13, what order was passed?
16 13 no, just skip.
It was
No.
passed over.
Mal.
Then why are you asking? No, it was passed over, then why are you asking? You were in code number 1 or 3 or 4 or 5, but you can ask the court master what has happened to my matter. You can ask him.
At first I saw.
Huh?
It is why lordship the moment I saw the.
So what permission? The matter is passed over, so you should wait for your turn.
I,
The why are you mentioning in between? You should wait for your turn. Learn some court etiquettes. If you do not, who is the senior?
I don't practice on the.
That's why you don't know, we don't know anything. Because we have not practiced with anyone. Just pass out and like come to the court and like you don't know anything about the ethics and all. No etiquettes, nothing. If matter is passed over, it will be taken up. No, we have not passed any order. Then you should wait for your turn. In between, you just come like a just like a person from Supreme Court has come and like mentioned before this court. Don't do this like do like this. So wait for your turn. We are calling the matters.
Kindly see annexure 1 minute, that is Agahar. Page 9.
Page 9.
9. 9 and 10, then 9 is relevant portion. Here in the fact is this, minute, the allegation is that minute, on the fixed date, 28/6/26. The the allegation is that the petitioner went to his house and attempted to commit rape. That is the allegation. No, there is no rape, minute. And the girl is minor, that is shown minute, 15 years. And the case has been registered under section 6 of the POCSO Act. Similarly, it does not follow under section 6 below. It is other section below. And the person-
Mr. Parasar?
If that being so, 6 will not come, but it is registered under 6, my lord. This is, my lord.
This is wrong section.
So we'll give him some interim then. Let it come. Heard Mr. A. Rashid, the learned counsel, appearing for the accused applicant. A.K. Parasar, learned APE for the state. There is no allegation of any this thing, only there. So we'll protect him for time being. Then let us see the CD. This is an application under section 482 of BNSS 2023, praying for granting bail, so and so, right? And you write, an FIR was lodged by the informant, by the informant, who is the mother of MSX, alleging that when her daughter was alone at home on 28/6/2026, at around 7 p.m., the accused applicant came to their house. They came to their home and attempted rape on her. It was full stop. It was alleged. It was also alleged. It was also alleged that the accused applicant it was also it was alleged that due to the fact the daughter of the informant was shocked and frightened and thereafter even tried to commit suicide. It was alleged that the accused applicant is a related uncle of the victim of the minor girl. Full stop. Mr. A. Rashid, learned counsel, appearing for the accused applicant, submits that there is no offense under section 6 of POCSO Act against. There is no allegation or omission of any offense under section 6 of POCSO Act. The 6 of POCSO Act, and and the accused applicant is a responsible person, and there is and the allegations that have been made are totally false and incorrect. He submits that he should be allowed to go go on interim pre-arrest bail. Taking into account the submission made by the accused applicant, submission made by the counsel appearing for the accused applicant, and also on provision of the FIR along with other materials, this court is of the opinion that some protection should be granted to the accused applicant at this stage. Accordingly, it is directed that in the event of the arrest of the accused applicant in connection with Sonai PS case number 16/2026, the accused applicant shall be granted interim pre-arrest bail on furnishing of a bail bond of rupees 50,000 with a security of like nature. Shall appear before the investigating officer within 7 days we appear, within 7 days of passing of this order, and shall cooperate with the investigation, full stop. Next you write, issue notice to respondent number 2 through Gauhati High Court notification, number 1 dispensed with. Then you write call for the CD. 5th of August. Let the matter fixed on 5th of August.
Item 10. I'm sorry to write because we have another time. My lord, your lordship will find another FIR is at page 11, my lord.
Page
Petition number
11.
1, he is the main accused, my lord. The petition number 2 and 3 are the parents, my lord. If it is the case, my lord, the petitioner that, my lord, in 2022.
Where is the type copy, Mr. Mukhtar?
Is my printed copy, my lord, because complaint case is there, my
Huh?
complaint petition has been annexed, my lord. Your lordship start from page 16, my lord.
No, there is no type copy of this, page 12.
Well.
You can't read this, it's so small.
Oh, my lord, your lordship can take, complaint petition is there, my lord. The entire thing is there, my lord. Complaint petition on the basis of which this has been made, my lord. In 2022, my lord, they got introduced, my lord, through Facebook, my lord. And immediately there was a romantic relationship, my lord. They also had some relation, both were major, my lord. This number 1 is 32 years, my lord, and C is 25 years, my lord. In the complaint case, we cooperated, we participated, my lord. I also will fully cooperate, my lord.
Complaint case, what happened?
Yes, my lord. This was issued to us, we appeared there, my lord, in the complaint case, my lord.
Then
This FIR was initiated, my lord. Was sent to police station, my lord. So we'll cooperate in this case also, my lord, definitely, my lord. Both are major, and anything happened, my lord, with due consent, my lord. If anything had happened at the time, my lord, because of this relationship, my lord.
64 is there, my lord. Statement of the girl is necessary, my lord. Maybe major, my lord, but under what circumstances, what, my lord. Let the CDB call, my lord. Udalguri, my lord, short date.
no, if there is some, now what is the allegation?
Yes,
Allegation is
rape-
what?
rape is there, my lord.
Rape is there, my lord.
Hmm.
64,
She says rape, my lord.
64 is, my lord, rape, my lord. So statement of the girl is necessary.
We'll cooperate, my lord, because we have to cooperate in all these cases, my lord.
So we'll see the CD, Mr. Mukhtar. I mean, let it come. We'll give a short date. We'll give a short date.
But at least petition number 2 and 3, my lord, parents may be, my lord, given, my
Our
lord.
parents can be granted,
my lord. Yes.
granted. 2 and 3 can be granted,
Yes, yes, ma'am.
given some protection. We heard Mr. S. Mukhtar, the learned counsel, appearing for the accused applicants. Also heard Mr. K.K. Parasar, learned APP for the state. This is an application under section 482 of BNSS 2023, praying for granting bail to the accused applicants in connection with Udalguri PS case number 49/2026 under section 61 in bracket 2 stroke 87, stroke 64, stroke 318, stroke 74, stroke 351, stroke 3 of the BNS 2023, BNS 2023. A complaint case was filed before the Chief Judicial Magistrate Kamrup Amingao by the informant, by the complainant stroke informant, alleging that the accused number one was in a relationship with her, with her, and with the false promise of marriage, sexually exploited her and committed rape on her. The accused person. There are four accused in the complaint.
I am for 3, madam.
Who is the other one?
He is a friend of the petitioner number 1, madam.
That accused number 4.
Accused number 3, madam.
Accused number 3 is the friend.
Yes, madam. Rafiqul Islam is the friend, madam.
And Anwara Begum is
Anwara
the.
Begum is mother, my lord.
Ah.
Abdul Karim is father, madam.
Okay. Accused number 2 is the mother of the accused number 1, and accused number 3 is the friend of the accused number 1, and accused number 4 is the father of the accused number 1. Full stop. The learned counsel appearing for the Mr. S. Mukhtar, learned counsel appearing for the accused applicants. Accused applicants submit that after the filing of the complaint, they have been participating in the proceeding and in the proceeding. Full stop. He submits that after the filing of the complaint, the FIR was lodged on. When was the FIR lodged?
Udalguri case, madam.
Udalguri case, it was filed on, okay, 7/7/2026.
Yes, madam. That was a.
Filed on
correct, we have-
7/0/2026. The learned counsel submits that accused applicant number 2 and 3 being the mother and father of the accused applicant number 1, they are not involved in the not involved in the instant case, and there are no specific allegations as such in the complaint or in the FIR registered against the accused applicants. Full stop. In view of the aforesaid, he praised that the accused applicant number 2 and 3 should be granted granted some protection at this stage. This court has gone through the matter and gone through the complaint case as well as the FIR lodged against the accused persons, and after being prima facie satisfied, it is direct that the accused applicant number 2 and 3 should be released on bail in the event of arrest, in the event of their arrest in connection with Udalguri PS case number 49/2026 by the arresting authority on furnishing of bail bond of rupees 20,000 each with surety of like nature, subject to the condition that the accused applicant number 2 and 3 shall appear before the investigating officer within a period of 7 days of passing of this order, and so shall cooperate with the investigation. Call for the CD. Leave the matter will be listed on
31st.
31st of July. 31st of July.
My lord. POCSO matter, my lord. I believe notice has to go, my lord.
Heard me, sir.
A Khan.
A Khan or F Khan?
A Khan, my lord. Dr.
Ek
Aziz,
Khanda learned counsel, appearing for the accused applicant, also heard Mr. K.K. Parasa. Then you write this is an application, take it from here, this is an application under so and so. Then you write notice to respondent number 2 as per the prevailing notification of the Gauhati High Court. Then you write notice to respondent number 1 is dispensed as Mr. K.K. Parasa has learned APP has put in his appearance. Then you write call for the CD, let the matter be fixed on when
31st.
31st of July.
Thank you.
My lord, the allegation is that from my pharmacy, my lord, some bottle of cough syrup has been seized, my lord. FIR is at page number 13. I have the license and I have also the purchasing receipt of those cough syrups, my lord. Page number 13 is the FIR, my lord. So allegation is that, my lord, 213 numbers of cough syrup bottle has been seized from my pharmacy as well as from my godown, my lord.
How many bottles?
As a whole, my lord, 213 bottles. But those bottles are legally purchased by me. I have the license of my pharmacy, and there is
The license is fine, but
bill also there, my lord.
Huh?
Bill also there, my lord. Bill.
193 for 200 bottles at the same time. Why do you
Because I
require so
have
much?
just purchased it, my lord. Thereafter, police raided and my lord. I have purchased it and I have stocked it. Then police raided and
The why police, if you have this, I mean, all these trade license and license for purchasing those.
because at that time, my lord, I was not in my pharmacy, my lord. Because of that, I could not produce the documents, my lord. And I was incorporated as an FIR named accused. Therefore, later on, I could not approach before the, my lord, police station apprehending arrest, my lord. And it is reflected in the FIR also. I was not present in the pharmacy, my lord. So at this stage, my lord, CD may be called for an interim protection will be given. I will submit all the documents, my lord. They may verify, my lord. Police may verify, my lord.
কোন ঠাই খাৰুপেটীয়া কিমান কথা কেছ নম্বৰটো খাৰুপেটীয়া
No, I will appear, my lord. I will submit all the documents, my lord. Police may verify, my lord. Because at that time, if I was in my pharmacy, I will produce all the documents, my lord.
Where are you?
I am the owner of the pharmacy, my lord.
Now, where were you when
Oh,
this?
I was outside, my lord. At that time, I was not in pharmacy. I went somewhere to some work, my lord. I went somewhere for some work. My employee was arrested, my lord, in this case, my lord.
No interim.
I will submit my lord.
No interim. Heard Mr. So-and-so learned counsel appearing for the accused applicant. Also heard Mr. K.K. Parasa learned APB for the state. This is an application under section 482. You just write this, huh? This is an application under so-and-so. Then you write allegations. Allegations relate to recovery of more than 200 bottles of cough syrup from the pharmacy owned by the accused applicant. Call for the CD. Let the matter be fixed on. Give a short date because I'm not giving him any interim.
on 29
28.
28 okay
28.
I also annex my invoice regarding the.
I understand. Those invoices are, I know, I mean,
Verify.
those are correct invoices, I know.
Lordship will find
Yes.
the FIR at page 8.
Page
Lordship
8.
will find the FIR at page 8 and 9. The petitioner before Lordship is a bright student of 22 years. There is no allegation against him in the FIR. The FIR speaks about online gaming and betting. And one of the accused, who is happened to be his brother-in-law, he was arrested in connection with this case and subsequently released by the lower court, Lordship. And the petitioner before Lordship has completed his graduation from Pandu College, and he was staying with his brother-in-law for pursuing competitive examinations. And that is why Lordship is apprehending arrest, since he was staying with his brother-in-law at Panjabari. In fact, he was not aware that his brother-in-law was engaged in online betting and gaming.
मतलब fact is that मतलब several images of मतलब sex and ATM cards of different individuals were found in his mobile. So, मतलब-
Yeah, his
no,
position.
from a digital documents expected to be connected with the illegal online gaming operation. The मतलब para 3 page 8 preliminary examination of the seized mobile phone.
Para, para.
Para 3 in page 8, my lord.
Page 8 of para 3.
Multiple fake users, ID, betting accounts, screenshots of betting and transaction.
No,
And
these all allegations are against these 6 accused persons. Your lordship will find the name of the accused persons at page number 9. They all were arrested and immediately granted bail also.
Jalukbari, my lord.
The accused number, the arrested accused number 4, Babul Islam is the brother-in-law of the petitioner.
You were staying in a different house.
They were staying together, lordship. He was
They
pursuing
are
his-
staying same house.
Yes.
From same house, these were all these materials have been recovered.
No, not from the house of Babul Islam. This was from some others.
Some other
because-
place.
Yes. Because this was from the Jalukbari, lordship. They were staying at Panjabari.
Let him go. I mean,
Well,
I mean, he's not named in the, he
He's
was
not
not,
named,
I mean,
He involved, my lord. He might
Ne-
be an involved, my lord.
see, in the,
If your lordship finds any involvement of him.
in the FIR, no mention of him.
His name is not there, my lord, yes.
His name is not there. And from a different place, these people are apprehended. Let him, I mean, he'll cooperate, Heard Mr. R. Bora, the learned counsel appearing for the accused applicant, also heard Mr. K.K. Parasar, learned APB for the state. There is an application under section 482 of BNSS 2023, paying for granting 2 years bail to the accused applicant in connection with Jalukbari PS case number 250/2026 under section 14 of Assam Game and Betting Act 1970, read with section 112/318 of BNSS. The allegations as alleged in the FIR, the facts leading to the filing of the instant AB application is that on 4/7/2026, an FIR was lodged before the Jalukbari, before the officer in charge Jalukbari police station, alleging that certain persons named in the certain persons who have been apprehended. One second. Alleging that on receipt of, alleging that on 3/7/2026, on receipt of certain information about illegal online gaming and betting activities, the police reached the spot and police reached the spot and found 6 persons engaged in online gambling and online gaming and betting, gambling and betting. The police apprehended those persons. Full stop. On receipt of the FIR, Jalukbari PS case number 250/2026 under the aforementioned sections was registered. The learned counsel appearing for the accused applicant submits that the accused applicant is the brother-in-law of one of the apprehended persons, namely Babul Islam. And he was not indulged in any kind of gaming or betting any kind of gambling and betting activities. He submits that he is a student preparing for some examination, and he was staying in a different house.
Yes.
He is staying in where
Greenland Port, Bagharbari, Panjabari.
he is staying in a place Panjabari, wherein the alleged offense of gambling and betting was going on in a place in Jalukbari. Full stop. The learned counsel submits that he is apprehended since his brother-in-law has been arrested by police. He is also apprehending arrest in the instant case. Full stop. He submits that he is a student and he will cooperate with the university. He is a student and preparing for some examination and shall cooperate with the investigation in the event of his in the event of any protection is granted by this court. Full stop. Taking into account the entire facts of the case, this court is of the considered opinion that the accused applicant should be granted pre-arrest bail in the incident case. Accordingly, it is directed that in the event of arrest of the accused applicant, the accused applicant shall be released on released on pre-arrest bail on punishing of bail bond of rupees 30,000 with a severity of like nature, subject to the following conditions. The accused applicant shall appear before the investigating authority in connection with mm, in connection with Jalipuri PS case number 250/2026. He shall be released. We have written this, no? Released on bail of 30,000 in connection of this case, subject to the satisfaction of the arresting authority, subject to the following conditions. And this appearance before 7 days, then he shall cooperate with the investigation and make himself available as and when called for. Then he shall not temper or hamper the investigation. Then we write in terms of the aforesaid direction, the instant heavy application disposed of. We have disposed of this.
So I'm sorry for.
No, that's fine. I mean, but you should understand and like you should learn these things. I mean,
Yes.
this is not the way to do it. I mean, your case is there are other cases which have been passed over. I cannot take up your case, before others. Why you should make this kind of, this thing?
So I learned
mention.
my lesson, Lord.
The way to do it.
Please, your lordship, that's regular bail application, lordship. NCP is,
I pray for some time, Lordship. Mr. Architect Chaudhary is out of station, Lordship. Now, affidavit, I'll reply.
You are also a counsel these days.
Lordship, I'm not, appearing for NCB, I'm only assisting him.
Huh?
For NCB, the Deputy Solicitor General is
Okay.
appearing, Lordship.
Okay, we'll give them some time.
lordship, from last 25/3, lordship, NCB was supposed to file objection, lordship.
Objection you have not filed.
It has been filed, Lordship, 24/4 on 20, it has been. filed.
Lordship, I had instruction from the senior counsel from opposite side, lordship, that the objection needs to be corrected and they will file a proper.
Clarification was needed, Lordship, but that was subsequent, Lordship, but it was filed.
He has intimated you.
Yes,
Then he is seeking for some time.
yes, lordship, short time may be given,
I
lordship.
heard Mr. D. Mehdi, the learned counsel appearing for the accused applicant. Also heard MSL Devi on behalf of Mr. R.K. Dev Chaudhary, the learned standing counsels, learned standing counsel.
Oh, Lordship, he is
No,
appearing
no,
as Deputy Solicitor.
R.K. Dev Chaudhary, the learned Deputy Solicitor General of India appearing for NCB. MSL Devi submits that Mr. Dev Chaudhary is out of station and please for a short accommodation, which is not objected by the learned counsel appearing for the accused applicant. Let the matter be fixed on when?
First
4th
week-
of August, lordship.
4th of August. Okay, 4th of August.
Deeply obliged.
Yeah, okay.
8 Peter Lordship. Lordship, this is a charge sheet at POXO case. Today is fixed for service report. I checked the office note dated 16/7. Service has been completed to the victim. However, they have not, we are yet to appoint a counsel. Lordship, this is the 4th date we are appearing and no one has appeared from the respondent number 2 side. Lordship, an amicus may be appointed and a short date may be given.
Service was affected on when?
Probably, Lordship, we have received the instruction, 18/6.
18/6.
Report has come on 16/7. By wide office note dated 16/7, that report has been flagged.
No, that's what I'm seeing, and that's why there is no date mentioned, that's why I'm asking him.
Exactly, Lord.
So whether you have checked any date?
No, Lordship, I was also perplexed regarding that, Lordship.
Huh?
That only says that service was completed.
That's why I have asked him that whether, when the service was affected. Is there any problem in
No,
asking?
no, Lord. I was just clarifying. Lord.
No clarification is required in all the time. If something is asked from you, then you reply. Be represented. Office note dated 16/7/2026 reveals that notice upon respondent number 2 has been served. However, when the matter was called for, no one appeared for respondent number 2. Next, in view of the service, in view of the completion of service, and since no one is appearing for respondent number 2, this court appoints amicus curiae. You were there in the list, no? Okay, this court appoints Trisita Parasar, T. Parasar, MST Parasar as the amicus to represent respondent number 2 and assist this court. Let this matter be listed on the learned counsel for the accused applicant shall service a copy of the application to the learned amicus curiae during the course of the day. Yes, in the course of the day, let the matter be listed on July 1st week sometime. July 1st week.
Oh.
He will serve you a copy.
August 1st. Not any date next.
Sorry, August, not July, August. On 4th of August. 4th of August. Let the matter be fixed on 4th of August. You give her a copy.
Deeply obliged.
36 Lordship, the service is complete, Lordship.
Service complete.
It was completed on 14/7. 14/7.
14/7. Today is we'll have to wait for some time, Mr. Huh? Some time should be given. Heard Mr. S.C. Vishwas, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, the learned deputy for the state. Mr. B. Sharma, the learned APV submits that service upon respondent number 2 has been completed. When did you say the date?
14/7.
14/7, completed on 14/7. Taking into account that the service on respondent number 2 has been executed only on 14/7/2026, let the matter be listed on 4th of July, 4th of August, 4th of August.
37, Lordship, there is an office note regarding service. It has not been received. Office note 16/7.
So it's not, service is still awaited. Parties are duly represented.
44 days, my lord.
Huh?
44 days, my lord. And
44 days.
14. Friday.
October matter is there.
14 has been, my lord.
Huh?
So 14, my lord.
14.
1/4.
Okay, we'll just give one date. I mean,
Prime accused has already been released. I am from the FIR also, my lord. Foxo is not attracted against the petitioner. He's the owner of the shop from where the photos were made viral by the accused. In the
okay, we'll fix it on 28. 28 or 29th. 29th we'll fix it. 29th of July. Okay. 29th will do. Or we can take it up this week only.
Lost idea.
Hmm?
I will take the instruction.
Okay, we'll take it up this week, 24th.
20.
If,
Commercial quantity.
Yes, no.
If it not received, let the matter be let the matter be listed again on
Next week, any-
this week.
Let it in the month of August, Lordship, first week. Commercial quantity, Lordship.
4th of August.
Yes, my lord, there was allegation of kidnapping.
It is received.
Period is over.
Huh? Period is over.
Allegation of kidnapping.
You were there for how many days? You were there for how many days?
101.
Then Lordship, I'll take the instruction.
103 days today.
I'll take the
So
instruction.
it's a 90 days thing.
I will take the.
Okay, you take the instruction.
After some time or
After some time. No, let them take the instructions.
Lordship. Item number. 42.
Did you receive?
Yes, Lordship. it is. 40 and 44, Lordship, are same case, Lordship, same affair. 40, 44, out of same affair.
44.
Yes.
Who is appearing for 44?
44, I am also.
You are only appearing. Okay. So what is the case?
Lordship case is in page number to FIR in 22, Lordship.
Hmm?
Gold smuggling case, Lordship, but nothing has been recovered from my position, Lordship.
You were behind the bars for how many days?
As on today, Lordship, in this item, Lordship, I have been shown arrested, Lordship. So as per shown arrested date, Lordship, I have been in 79 days as on today, Lordship. And in total, 87 days behind.
79 days.
79 days.
Lordship will kindly take up item number 44 and there is a rejection order of your Lordship. That will make everything clear, Lordship.
Okay.
44, page number 33. Order dated 9/6/26 passed by your Lordship.
And item 44, Lordship, as on today, 87 behind our Lordship.
How many days? 44?
44 said 87 days.
Yes, what is there in the CD?
Lordship, investigation has progressed, Lordship. Some Hawala transaction are there. They are involved in fake gold cases. Lordship has already dealt with it. And investigation to the effect is still pending, Lordship, still going on.
87 days. We grant him. And what about the other case?
Other case, Lordship, from him, the gold biscuits were seized, Lordship. In respect of him also, Lordship, investigation has progressed, Lordship.
Let them go.
He is 79 days
Take demands.
to my calculation, Lordship.
Okay, right. Heard Mr.
Yes, sir.
S. Hussain, the learned counsel appearing for the accused applicant, also heard Mr. B. Sharma, the learned APP for the state. Reason application under section 483 of BNSS 2023, praying for granting bail to the accused applicant. Applicant in connection with Balpeta PS case number 132/2026, registered under section 61 in bracket 2/318(4)/111(4)/111 bracket 4/3 bracket 5 of BNS 2023. Then you take this page 34. 34, you take the paragraph 3, that FIR details were. Then you write, after receipt of the FIR, please register the Balpeta PS case number 132/2026 under the aforementioned sections. The learned counsel appearing for the accused applicant submits that he is behind the bars for last 87 days. 87 days and 87 days. And nothing has been recovered from him. Taking into account from him in view of the aforesaid and also due to his long detention behind the bars, he submits that the accused applicant should be granted the bail at this stage, full stop. Taking into it, CD in the instant case has been produced before this court, and the same is produced. Taking into account the fact that nothing has been recovered from him, from the accused applicant, and also of the fact that he has already spent 87 days behind the bars. This court is of the opinion that the accused applicant should be granted bail at this stage. Accordingly, it is directed that the accused applicant shall be released immediately on furnishing of a bail bond of rupees 50,000 with a surety of like nature, subject to the satisfaction of the which court?
Lordship, Borpata.
Huh?
Borpata.
No, Borpata?
CGM, Lordship.
To the satisfaction of the learned CGM, Borpata, subject to the following conditions. Number one, that he will cooperate with the investigation and he shall not tamper and hamper with the investigation. Okay. In terms of the next para, in terms of the direction, the instant AB application is disposed of. Bail application is disposed of. And para 3, you take flag mark data. 30,000. The other one you take as same FIR, no?
Same FIR, out of same.
FIR is same, application and all this thing you write. Then you write that he is behind the bars for 79 days. 79 days and submission on it that nothing has been recovered to don't write anything. That he is behind the bars for 79 days in the instant case wherein he has been shown arrest. Then Baki we keep it same. Okay, we are disposing of it.
41 Lordship, there is a office note, 16, office note dated 16/7/26. Service report is awaited, Lordship.
Okay. The parties are duly represented. Office note dated 16/7/2026 reveals that service report regarding service of notice upon respondent number 2 is yet to be received. Let the matter be listed on 29th of July. 29th of July.
42 Lordship, service is complete, Lordship.
Any idea when? 1 second.
The date is not here, Lordship.
So we'll wait for one more date. It was served only in 13, 14, something like that.
Short date maybe. It is already.
Parties are duly represented. Then you write parties are duly represented. Office note dated 17/7/2026 reveals that service of notice on respondent number 2 has been completed. Full stop. Has been completed. let the matter be fixed on 29th of July. None appeared for the respondent number 2. Those services completed, none appeared for respondent number 2.
That is your lordship.
Hmm.
That my lord illegal.
Yes, if they have notification.
Today is my lord 35 days in custody. Lady my lord has a small.
This
5 years.
lordship will find at the third page, there is reference to a advisory from the ministry lordship. Apart from that, nothing was provided to me lordship.
Mr. Sharma, are they aware of this or not? Your senior officers are aware or not? They were not aware probably, it looks like.
Only this much information I could gather.
So this is a committee for the committee they have formed for many things. But this is not for this. This is not a committee cannot. Go for investigation.
Only that part, lordship, I had some. I asked them, lordship, as per guidelines of Ministry of Home Affairs. I also asked them if the
So
guidelines
Ministry
came
of Home Affairs doesn't have anything to do. Doesn't have anything to do. What I mean is that the CRPC statute specifically provides for this.
Yes.
So as part of statute, you need to appoint somebody as a special officer. So that you have not done here.
lordship. So
And I think they are not aware also because they are submitting certain documents to you, which may not be very relevant to the, relevant to the issue.
probably-
Though it's a immoral traffic, aspect of immoral trafficking is involved. But this is something which is a committee. Committee have been formed, no nodal officer have been formed, but this is no
This-
notification from the government.
district level anti-human trafficking unit.
Correct. So unit means what? Now, who is the person how? The all,
This mention, lordship,
This-
it is comprised of one nodal officer.
now, one nodal
inspector.
officer, GO, one inspector, two sub-inspectors, so and so, and who is the special officer? You see the CRP, this thing provision.
Yes, I understand.
Provision is very clear.
Yes, yes.
It seems like they are not aware of this. Your DGP is not aware.
Probably, lordship.
Your DGP, IGP, nobody is aware probably. There a special officer has to be,
Probably, lordship, I'll have to forward it to the DOP. DOP will have to take
you'll have
steps
to
in that
find it
regard.
out because, this doesn't say anything about specially, appointing a special officer.
Yes.
So we'll have to allow him.
Lordship.
There's no other way. We'll pass the order in the second half. Mr. Babu, you Chaudhary, you can be present. We'll take it up and pass the order in the court itself, but because let me finish this, then it will take some time, this passing this order. Second half will pass.
One order of my lord regarding period of detention, your lordship has passed, my lord, after 22 days, my lord.
What is it?
But that special police officer point was not there in.
No, it was not raised there.
It
It
was
was not raised.
only on period of detention.
Okay, we'll pass this order in the second half. We'll call the matter, then
At 2, my lord.
not at 2 will be difficult. 3 o'clock,
My lord.
3 o'clock, okay, 3 o'clock we'll call this. And we'll pass the order here only, but it will take some time because it needs to quote certain things.
My lord.
So 3 o'clock we'll take it. পাঁচ
Formalize
জন। বিষয় এটা 3টা বাজে মোক চেম্বাৰত দি দিব তাহলে 3টা বাজে আমি এইটো অর্ডার পাস করি once again.
45.
Lunch up club silent.
So related to immoral trafficking, Lordship. This is also related to immoral trafficking, Lordship.
Human trafficking only.
Yes, but may I state, Lordship, one thing? This petitioner, Lordship, he has been found to be the customer of the immoral act, Lordship. So in that regard, Lordship, he was arrested on 31/5. So rest I leave it to your Lordship, because here also the same question will come and
My
I
lord,
could not find it, Lordship.
I want to rely with due respect, some judgment.
Yeah, I mean, he's relying on some judgments by coordinate bench wherein, I mean, that issue was probably not raised.
So we'll not-
Only on the factual background, I mean, bails have been granted. And last time also he was trying to,
it's
I
okay.
mean, impress upon,
I
but
understand.
only because of the CD was not available,
Yes,
this court
yes,
did not. So I think will allow
He is
him.
on a different footing, Lordship, because
Yeah. He's a customer.
Yes,
kind
yes,
of
ma'am.
thing. He was not
that
exactly.
wanted to place before, Lordship.
Is in the judicial custody 51 days, my lord, till today. Earlier obliged.
Heard Mr. A.K. Hannan. A.K. Hannan, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, the learned APP for the state. This is an application under section 483 of BNSS, 2023, praying for granting bail to the accused applicant in connection with Nagaon PS case number 299/2026 under section 143 of BNS 2023, read with sections 3/4/5/7 of immoral traffic in bracket prevention, bracket complete Act 1956. The learned counsel appearing for the, then you write. One, then you write, an FIR was lodged by one SI, namely Nobadon Goswami, before the officer in charge of Nagaon Sadar Police Station on 30/5/2026, alleging that on 30/5/2026, on receipt of certain reliable sources about some immoral activities being carried out at Rising Sun Line Hotel situated in Borghat bypass, he along with his staff reached the place, and after conducting a raid, two alleged victims were rescued and 6 accused persons were apprehended. Full stop. It was alleged that one Mosaidul Islam forced the woman into prostitution, and one Rakib Ali was involved in nexus who supplied women to various customers. On receipt of the FIR, the police lodged Nagaon PS case number 399/2026 under the aforementioned sections. You are apprehended from the spot?
Yes, ma'am.
The learned counsel, the CD in instant case has been received and the same is produced. The learned counsel appearing for the accused applicant submits that all have been granted bail.
One accused person, even till today, did not apply
The
for
main
bail
accused,
application.
Lordship, is absconding.
Main accused absconding.
Main absconding.
Yes, Rekib Ali.
Rakib Ali is absconding,
Yes,
and the apprehended customers all
Yes,
granted
all
bail.
are released on bail.
Ah.
And who operates the hotel also granted bail. by
Granted bail.
Musahid.
He submits that all the apprehended customers have been granted by bail by the coordinate benches of this court. He further submits that the owner of the hotel, from where the persons were apprehended, was also granted bail by a coordinate bench of this court. In view of the episode, he submits that the present accused applicant should be also granted bail at this stage, who has spent who is behind the bars for how many days?
51 days, my lord.
51 days, behind the bars for 51 days first. The next para, taking into account the submission made by the counsel appearing for the respective parties and on perusal of the case diary, as well as taking into account the orders of bail granted by court in advances, this court is of the considered opinion that the accused applicant should be released immediately on furnishing of a bail bond of rupees 30,000 with a security of like nature to the satisfaction of the which court?
Nagaon.
Nagaon?
Nagaon CCM.
The learned court, learned CGM,
Yes.
Nagaon. Nagaon, subject to the condition that accused applicant shall cooperate with the investigation and make himself available as and when called for by the investigating officer. Next para. In terms of the aforesaid direction, the instant bail application is disposed of as allowed.
Held your place, my lord.
47, 48, 49.
PD not received, Lordship.
Hmm.
They are on interim. 47 is on interim.
Hmm.
Item number 47, the person is an interim. I am appearing in 48. My prayer for interim may be considered. Yes.
1 second. 47 is in interim then and
CD not received, Lordship.
CD not received.
CD not
48? 48 why? What kind of allegation?
Attempt to murder. This small scuffle has happened in the roadside and they have invoked attempt to murder. FIR is at page 90. If I may read it.
48 and 49, same.
Same.
I am appearing only for 48.
Where is the FIR?
At page 90.
Now, where is the order passed in 47? 1 second. 1 second.
Page 90.
Hmm?
90, page FIR. May I read, man?
I'll just go, wait for some time.
May I place one thing?
CD, what is there?
CD not
Is there
received.
any CD not received?
But Lordship, may I place,
Hmm.
Lordship, page 28.
20?
8. Just for a moment. Lordship, kindly come to page 29, second page of the order dated 11/3/26.
Hmm.
Second page, Lordship, at
Hmm.
page 29. Lordship will see point number 6. Upon perusal of the case study, it appears that the victim has sustained injury which is simple in nature.
Heard,
Here.
and who is appearing for 47?
47.
47? Case there is not received.
Is there-
I mean, I don't think, I mean, there is, I mean, I think we can
Dispose of.
dispose of these cases. I mean, there is nothing, absolutely nothing. The 47 you write, I heard, 47 you write, your name? So and so, so and so, but the accused applicant also heard, Mr. Deep Sharma, the learned APP for the state. And this is an application under section 482 of BNSS 2023, praying for granting pre-arrest bail to the accused applicant in connection with Dhubri PS case number 42/2026 under sections for 281/125 bracket small a stroke 61 bracket 2 stroke 126 bracket 2 stroke 117 bracket 2 stroke 109 bracket 1 stroke 303 bracket 2 stroke 296 bracket 296 stroke 351 bracket 3 stroke 3 bracket 5 of BNS 2023. An FIR was lodged on 7/2/2026 where the informant alleging that on 7/2/2026 while he was 7/0/2026 in the morning while he was traveling, he was going to Happy Convent School, Dhubri, to drop his daughter at Vidya Paratiniali, one e-rickshaw driven in a rash and negligent manner collided with the motorcycle of the informant. It was alleged that as a result, the minor daughter of the informant got certain injuries. Then it was also alleged that he took a photograph of the e-rickshaw and e-rickshaw to inform the police. It was alleged that on seeing that the accused applicant threatened the informant and threatened the informant. Then while he was coming back from dropping his daughter in school, it was alleged that the accused applicant along with some other persons have assaulted him. On receipt of the FIR, police registered the WPS case number 42/2026 under the aforementioned sections. The learned counsel appearing for the accused applicant submits that the accused applicant was granted interim bail by this court by order the 23/3/2026 and 2026 and he submits that the injury as alleged is only of simple nature and therefore the interim order passed in the instant case should be made absolute, taking into account the entire facts of the case as well as upon hearing the counsel appearing for the respective parties, this court has the opinion that the instant bail, the interim bail order passed on 23/3/2026 should be made absolute. Accordingly, the instant AV application is disposed of making absolute the interim pre-arrest bail order dated 23/3/2026. We just come back in 5 minutes. Other two I'm passing. Forty-eight, you write. Same application and the same application, same FI. Contents will be same. The learned counsel appearing for the accused applicant submits that Mansoor Sheikh was the driver.
Nazimuddin Rahman was a
Who is Mansoor Sheikh?
Yeah.
Para 4.
Yeah.
These people are granted bail.
He, yes, Your Lordship. He
Hmm?
was arrested. Initially, he was arrested.
The learned counsel appearing for the accused applicant submits that the accused applicant is not involved in the incident and not involved in the incident, and he has been falsely no, there are two persons, huh? So applicants are not involved, and they have been falsely implicated in the incident case. Also, he further submits that some of the accused persons have already been granted. Some of the accused persons have already been granted bail. Already granted bail. Therefore, he submits that the accused applicant who is also apprehending arrest should be released on pre-arrest bail. Taking into account the entire facts of the case, this court is of the considered opinion that accused applicants should be granted pre-arrest bail at this stage. Accordingly, it is directed that in the event of arrest of the accused applicants, the accused applicants shall be released on bail, furnishing a bail bond of ₹20,000 each, with the severity of like nature to the satisfaction of the arresting authority, subject to the conditions that accused applicants shall appear before the investigating officer within a period of 10 days of passing of this order. The accused applicant shall cooperate with the investigation and should make themselves available as and when called for. The accused applicant shall not tamper or hamper with the investigation. Then you write, in terms of the aforesaid direction, the instant AB application is disposed of.
So great.
This is also same order will go. Same FIR, same order will go. Item number 49 also same order. Only his name will be different. What is your name? A collect. All others will be same.
May it please your lordship. 482 anticipatory bail application. Lordship, FIR is at page number 14. Here, your lordship, the accused person is the husband of the victim girl, and the informant is a total stranger to the case, your lordship. The victim also does not know who the stranger is. I and the victim were living as husband and wife.
Anybody is appearing for a respondent?
Appearing for
Respondent number 2? You are appearing?
Not respondent number 2, your lordship, victim.
Victim.
And informant is a stranger, total stranger.
Malat, this is a malat, FOXO has come malat because of this child marriage case malat. The informant may be stranger malat, we don't know malat. Other person also in child marriage case malat. But
Cognizance have been taken. I am ready to participate in the trial. However, no marriage certificate or any kind of thing was seized. My marriage was not solemnized in 2023 at the date of the FIR, your lordship. It happened after the victim has attained the age of 18 and I also have attained the age of majority. At this stage, allow me to participate in the trial, your lordship. Page number 14 is the FIR.
Twenty-three subject, no? 23 subject.
What happened to the Qazi? He's been arrested.
Your lordship, I am also unaware about the Qazi, your lordship. The informant knows about the Qazi and the informant is also a stranger to me, your lordship.
I am totally unaware why I'm involved in this case. Your Lordship.
Why why unable you are married?
We have married in the year 2024. That is 1 year after she.
Correct, 1 year, but age has been mentioned as 17 years.
17 years by the informant, Your Lordship. Why the
Yes.
informant mentions my age without clarification with me, that is up to the informant's wisdom, Your Lordship.
Has informant has given any details
No, Your
in
Lordship.
your objection? Have you given any details of the girl? That she is a minor where?
My date of birth is 20/11/2005.
Not your birth of girl, not your birth. I mean, the birth of the girl victim.
Victim.
Any certificate you have given?
Other.
Aadhaar card has been annexed.
Other. On page 31.
Please,
Page 31.
31.
Affidavit.
Speak little bit loudly. What?
While in the additional affidavit,
The additional
affidavit they have filed.
No, additional affidavit
No,
file.
affidavit they have filed, my lord.
Affidavit is not there. Affidavit. এইবিলাক আছে নেকি? এইখনটো reply ফাইল কৰিছে। This is affidavit in opposition. You have filed this. And somewhere you are writing this is affidavit in opposition, somewhere you are writing it is affidavit in reply. What is your name?
A.S. Chaudhary. A.S. Chaudhary.
So why do you write somewhere affidavit in opposition, somewhere affidavit in reply? Date of birth 2005.
20,
Date of birth 2005. That means
2011/2000.
Yes.
Hmm?
Married in 2024, around more than 18 years.
more than 18
19.
years. Huh?
19 years.
So if you are yourself, you are saying that she is not child. Then why are you objecting?
No, I am not objecting.
Then
I am not objecting. I put my affidavit. I am not objecting.
you are appearing for whom?
On behalf of victim.
Behalf of the victim,
Not the
not for the informant.
Someone issued in page 24, my lord. That order, my lord, not someone.
Okay, we are disposing of this. I mean,
Okay,
let
they
them,
will participate in the file.
appear. Heard Mr.
T.L. Oscar.
T.L. Oscar, the learned counsel, appearing for the accused applicant. Also heard Mr. K.K. Parasar, learned APP for the state, as well as Mr.
A.S. Chaudhary.
A. Chaudhary for respondent number 2. Respondent number 2 is who? The father.
Lordship.
Respondent number 2 is the.
Respondent number 2 is an informant who is a total stranger to the husband and the wife.
I
He is
am
for the
therefore
victim.
You are appearing for victim.
Respondent.
How can you say respondent? Respondent
Not
to
respondent, not respondent. Only victim, Your Lordship, not respondent.
Right. This is an application under 482 of BNSS 2023, going for bail to the accused applicant in connection with special POCSO case number 120 in bracket H of 2024 pending before the learned court of special judge Vijay. And what is the stage of this?
Lordship, appearance stage, after someone has been served, I will appear, then charge you. Consideration of charges.
Did you write, an FIR was lodged on 3/2/2023 by one Mukhtar Ali, the Mukhtar Ali. Before the officer in charge Lanka Police Station. On 3/2/2023, alleging that one person, namely Farooq Ahmed, in bracket Kaji, has solemnized the marriage of a girl, namely MSX, who is 17 years old, with one Saharul Islam, who is 24 years of age, at Udali Bazaar. It was alleged that the aforesaid Kaji has, as aforesaid Farooq Ahmed, has been performing marriage ceremonies of underage girls, underage in bracket comma minor girls with adult males for several years. On receipt of the FIR, police registered Lanka PS case number 100/2023 under the aforementioned sections. After the investigation, police submitted the charge sheet, and at present the matter is pending at appearance stage. Full stop. The learned counsel appearing for the accused applicant submits that the girl concerned is a major, and the person who has married the girl is also a major. Therefore, there is no offense committed by the marriage by the accused applicant with the concerned girl. Mr. A.S. Chaudhary, the learned counsel appearing for the victim girl, has submitted an affidavit in the instant case wherein the other court of the girl has been annexed. On perusal of the same, it reveals that the girl was a measure when the marriage ceremony. Prima facie reveals prima facie that the girl is a measure when the marriage was solemnized. Taking into account the aforesaid, this court is of the view that the accused applicant should be granted bail. Granted pre-arrest bail at this stage. Accordingly, it is directed that in the event of arrest of the accused applicant in connection with special POCSO case number 102 in bracket H capital H of 2024, the accused applicant should be released on bail on furnishing of a bail bond of 30,000 to the satisfaction of the learned court of the special judge in bracket POCSO Vijay, subject to the conditions that the accused applicant shall appear before the trial court as and when required, and the accused applicant shall not try to influence any witness or evidence that may be involved in the instant case. Also, in terms of the aforesaid directions, the instant AB application is disposed of as allowed.
And declare fair.
Okay, the senior advocate is still on legs. He's still on legs.
Still on legs. Okay, pass it over for.
Petition under section 482, paying for granting anticipatory bill. Lordship, the FIR in page number 18, Lordship. FIR is long, may I read, Lordship?
Yes.
This is only CD,
Hmm?
only case there, my lord.
Lordship, this wrongly added section 6 and section 9, section 6 of the.
But you have allegation is that you have forged the birth
Forged the
certificate also.
They get all.
So let us see what is there in the CD.
Lordship.
Heard MS.
Lordship, she is a Gau Panchayat, president of Dharmashala Gau Panchayat, Lordship. If in this time she arrested, maybe some consequential different, Lordship, because she is a woman and she have two minor.
But she has issued the birth certificate, isn't it?
Lordship, she's issue not because the genuineness of the birth certificate, Lordship, which one is genuine or not, that is the proof in the trial, Lordship, not in this moment, Lordship. In this moment, Lordship, if she arrested, then Lordship,
So tell me what is the allegation against her?
false birth certificate,
Huh?
Lordship, false birth
False birth certificate. So we'll have to see what is there, what are the what materials are there. No, we'll give a short date. Now, I mean, if a Gaon Panchayat is supposed to for the welfare of the people, you cannot force
And that
documents.
same kind of allegation already she faced, Lordship, because of the ADC already issued a statutory proceeding, Lordship, and the next date fixing 21st of.
That's a
July,
different proceeding. So that means that means she has other incidents also against her.
My lord,
At this stage, we'll see the, I mean, this thing.
CD
Heard MSA Begum, the learned counsel appearing for the accused applicant, also heard Mr. K. Parasar, learned AP for the state, and
Respondent DK Agrawal. For
DK Agrawal for
respondent number 2.
respondent number 2. Then you write, this is an application, so and so, so and so. Then you write, call for the CD.
informant.
Let the matter be fixed on when?
My lord, 31st.
31st is too long.
Please, I mean,
4th August.
Oh. 29, my lord.
let it be fixed on 29th.
A copy may be given to sir.
Lordship, I will.
Grateful.
Much obliged.
May I please have Lordship, my lord? Lord, this is a pre-arrest bail application, my lord. FIR is at page 11, my lord. The informant, my lord, herself is the victim's mother, my lord, and she has admitted that there was a love affair.
Respondent number 2, somebody is appearing. Respondent number 2, anybody is appearing?
Some name has been added. One Datta was there, my lord.
Hmm?
On last occasion, my lord, one Datta was there, some Datta, my lord.
Somebody is appearing last time.
Yes. ma'am. And in fact, my lord, the medical
I
report.
mean, this is a POXO matter, right?
POXO matter, but the medical report as well as the FIR, my lord. If your lordship kindly go through the FIR as well as the medical report. It says
But
that,
now nobody is there for respondent number 2. We'll have to hear them.
my lord, the medical report says that the age of the girl is in between 18 to 19 years, my lord. If I take your lordship to the medical report, my lord, also, my lord, page 16, my lord. Annexure 2, my lord. In the last column, my lord, opinions, there was no mark of injury, nothing was there, my lord. And the age of the victim is, my lord, in between 18 to 19 years. My lord. Page 16, annexure 2, my lord.
183 statement she implicated, my lord, I have flag mark, my lord.
And it is purely love affair, my lord, that has been admitted in the affair itself by the mother of the victim girl, my lord, informant.
Physical relationship, thereafter, viral the photographs and all these, my lord.
These are, my lord, false allegations. Nothing is there. Suppose, my lord, nothing will come in the record itself. My lord. Very sure, my lord. There was a rivalry, my lord, in between the petitioner and the father of the victim girl, my lord. That is the background of the story, my lord. This is purely love affair, my lord. Affair, say. Lord, in fact, in the charge sheet also, my lord, there was no, my lord, independent witness, my lord. All the witnesses have been shown, my lord, are the family members of the, my lord, informant, the victim.
Victim statement, my lord, it's very clear, my lord. 183 statement, she is clearly implicated, my lord.
Presumption is there.
Lord, it is purely love affair that has been admitted in the affair.
Love affair is fine, but like,
Yes, and the
only
age of
because
the
love
victim
affair,
girl
you
is
can't have physical
the
relationship
radiological report, my lord.
with a minor girl.
The medical report.
So
my lord.
that is the law.
Lord, the medical report says, my lord, the girl is, my lord, in between 18 to 19 years, my lord.
The medical report, what test has been done?
Lord,
What test has been done in medical report? Classification test or
Medical
what?
report always, my lord, 2 years, my lord. In Mirana, she clearly mentioned her age is 17 in one statement.
Where is the medical report?
Page, my lord, 16, my lord.
Page
Annexure
16.
Yes, my lord. In the opinion column, my lord, last bottom, my lord. Her age is between 18 and 19 years, as per radiologist opinion. There is no evidence of, and the no mark of injury, my lord.
Medical test was done when?
On the very next day, my lord. Affair was lodged on 19th.
2025.
It was done on, my lord, 20th of, my lord, March, my lord. Very next day, my lord.
This is only an opinion without any test.
Lord, the question is, my lord, my custodial detention may not be required, my
Yeah,
lord.
required. In POCSO matter required.
My
Why
lord,
not? You'll influence
my lord,
you'll influence all the witnesses. How the trial will proceed if you
my lord,
influence.
cooperate, my lord,
If
with
the
my
whole trial will be
there
vitiated,
will be no hamper.
whole trial
Nothing
will be
will be there,
vitiated.
my lord. Nothing.
And as per
There
the
is no
statement
threat,
of the girl, my lord, he is a married person, my lord.
And the other person is also not there today.
Let the other person appear, my lord.
Okay, we are putting it some other day. Day after tomorrow. Mr. J. Hamad, the learned counsel, is present for the accused applicant. Mr. K. Parasar, learned APP is present. However, the counsel, however, no one appeared for respondent number 2. Let the matter be listed on 22nd, on 22nd July. TCR to be retained. Scan computer TCR to be retained.
Charge sheet submitted in evening.
But here, my lord, we have also made party respondent number 2. Subsequently, POCSO has been added.
The charge sheet submitted, you go there.
We have also found, my lord, notice 36 and 48.
You go there. But charge sheet submitted, you go there, you raise all these grounds. Heard Mr. Amar Khandekar.
Service of record, my lord.
Huh?
Notice has been issued to respondent number two.
Correct, I mean, it is irrelevant now, but church, I mean, how you will be helped?
But my.
How you will be, no, you tell me how you will be
I
helped
have
with this?
also taken two grounds. my lord.
That those who raised there, heard Mr. Amar Khandekar, Learned Counsel appearing for the accused applicant. Also heard Mr. K.K. Parasar, Learned AP for the state. This is an application under section 480 and 483 of VNSS 203, ये लिखो इसको, application under so and so. Then learned Mr. K.K. Parasar, Learned APP has submitted that charge sheet in the instant case has already been filed by charge sheet number
Case number 59/26,
59
dated 28/4/26.
In view of the aforesaid, the learned counsel appearing for the accused applicant submits that liberty should be given to him to approach the jurisdictional court for appropriate relief. In view of the aforesaid submission, the instant bail application is disposed of with liberty to the accused applicant to approach the jurisdictional court for appropriate for any relief if so advised. In terms of the disposed of, yeah. CDS come.
Yes, after the interim order, I went to the police and recorded my statement. If your lordship looks into the affair at page 19, my brother along with two other boys, they came to Gauhati and they said by mistake they brought my license revolver. They were arrested, granted bail, and at this stage, my lord, my custodial detention may not be necessary for the investigation of the case.
I mean, your brother and
Two other boys, they came to Gauhati. By mistake, the bag where my gun was put, it was in the bag which they were carrying. So they were.
they carried forward.
No reason, by mistake it came in the bag. They say, they were arrested, released on bail. I am the license holder. If I have violated the condition, that will be a different proceeding, but custodial detention may not be necessary. There is no allegation of any unlawful activities or any of that sort.
Okay, Mr.
Yes, but he is the licensee holder of that revolver lordship. And
So the process will follow. I don't think the custodial detention is recovered. The pistol has been recovered. Pistol is always there. And he has appeared.
He has appeared in the statement recorded.
Yes, heard Mr. B.D. Kuwar, learned senior counsel, assisted by Mr. H. Agarwal, learned counsel appearing for the accused applicant. Also heard Mr. D.P. Goswami, learned AP for the state. An FIR was lodged on 2/4/2026, alleging that the license revolver of the accused applicant was
Webley and Scott. Page 19, the number, Webley and Scott, page 19. Made in England.
Revolver was found to be carried by three persons at the Gauhati exit gate of Gauhati railway station. It was alleged that the pistol was the revolver was seized by the police, and thereafter GRPS case number 69/2026 was registered under section 25 in bracket 1B of 1B and bracket A of Arms Act. A coordinate bench of this court, right order dated 13/5/2026, has granted interim pre-arrest bail to the accused applicant. CD in the instant case has been received, and the same is pre-arrest. The senior counsel submits that he is the licensed owner of the revolver that has been seized from the persons who are, who are his relatives, and one of them is his relative, and others are acquaintances. He submits that the bag wherein the revolver was kept was mistakenly carried by those three persons, as alleged in the FIR. He submits that since the accused applicant has already appeared before the investigating officer and got his statements recorded, further custodial retention of the accused applicant may not be required in the instant case. Taking this court, after perusal of the case diary and after hearing and on hearing of the counsel appearing both the respective parties, this court is of the considered opinion that the order with the 13-5-2026, whereby interim pre-arrest bail was granted to the accused applicant, should be made absolute. Accordingly, the instant AB application is disposed of by making the order with the 13-5-2026 absolute. Disposed of. You are thinking something about about your look or what?
Mr. Lordship,
Yes.
Lordship, senior counsel is out of station.
Who is your senior counsel?
M. Ali,
M. Ali, where is he?
Lordship, due to flight.
Huh? Where is he? He is not there.
For the day, Lordship, at some point.
If he is not there, we'll cancel the bail, whatever the bail is, the bail that has been granted.
Water logging, my lord, senior.
Water logging till now?
Okay.
On the prayer of the counsel appearing for the accused applicant, let the matter be listed on 22nd July.
Case diary, my lord.
Case diary to be retained, interim order so passed earlier shall continue till the next day of listing. 22nd, okay? You go and appear there. Your name?
MK Hussain.
Heard Mr. M.K. Hussain, the learned counsel appearing for the accused applicant. Also heard Mr. D.P. Goswami, the learned APP for the state, as well as Mr. M. Sheikh, the learned counsel for respondent number 2. Respondent number 2, full stop. And this is an application you write, then you write the learned APP, Mr. D.P. Goswami submits that charge sheet in the instant case has already been filed by charge sheet number
63/26 dated 18/7/26.
26. Next para. In view of the aforesaid, the learned counsel appearing for the accused applicant submits that he should be given liberty to approach the appropriate court for approach the jurisdictional court for appropriate relief. Full stop. Instant AB application is disposed of with liberty to the accused applicant to approach the jurisdictional court if so advised.
86. We have not received the case diary.
In this case.
Is there a receipt?
Not received.
In this case, petitioner number 2 already arrested.
Petitioner number 2 already arrested.
My lord, and I'm petitioner number is on interim. Petitioner number is on interim, Lordship. FIR is page number 20, Lordship. There is nothing against the allegations against the petitioner number 1, Lordship.
Let the case diary come then. Lordship. Let the case diary come. We can. The POXO matter.
My lord.
You are appearing for us. Okay, case diary not part. Your name?
R. Burwa.
Mr. R. Burwa is present for the accused applicants. Mr. K.K. Parasar Yeah, is present. Mr. VP Goswami is present for the, if the DPP is present, as well as Mr.
M. Arif.
Huh?
M. Arif.
Arif for respondent number 2. It is the case, case that is not received. Data matter be listed on 28th of July.
What's it interim against the web?
Interim order so past arrest shall continue.
Declare.
But he has already been arrested, no? One is arrested. No, interim was given to whom? Also,
One.
only one.
Only one.
Interim order passed in favor of respondent number 1. In favor of the accused applicant number 1 is extended.
Okay.
Yes.
May I please, Your Lord?
TDS come.
Yes, come, my lord. My lord, I beg to draw my lordship's attention to the, my lord, first information report, my lord, is at page 21. Starts at page 21. Contents, a very type copy. My lord, I'm, my lord, troubling my lordships with the type copy, my lord. Is that starts at page 17, annexure 1, my lord. It's a very long FIR, my lord. My lord can skip the first part, page 19, description of the seizure, my lord. 8 cartons of tripropylidine hydrochloride and codeine phosphate syrup of 100 ml bottle, batch number so and so, dated so and so, of rupees so and so, brand name so and so has been, my lord, alleged to be seized from my godown, my lord. Carton containing 120 bottles, one packet containing 100 bottles, total 220 bottles. So, my lord, this is the allegation that these contents or the substance which has been seized, my lord, the case of the prosecution is that, my lord, it falls within the NDPS Act. Now, my lord, our contention is that, my lord, this is not, I am a, my lord, registered, a licensed distributor, wholesale distributor of medicines, my lord. For that, my lord, I beg to draw my lordship's attention to my license is at page 33.
Okay, you have a license then?
Then, my lord, I have purchased this material by, my lord, by paying the valid GST invoice. That is also there, my lord, is at page 38. So therefore, my lord, the allegation which has been they have brought in is a, my lord, that this falls within the category of NDPS, does not come within the purview of the meaning of the NDPS definition, my lord. And for that, I relied on a, my lord, document, page number 39, my lord. This is the type copy of the original manufactured narcotic drugs, my lord, which that how this is required to be treated, my lord, codeine. Methyl morphine, commonly known as codeine, and ethyl morphine, and their salt.
So you are, your basic thing is that like you have bought this thing under the license and like as
License and paying.
and who are you? You are who?
I am a, my lord, wholesale distributor.
Wholesale distributor.
So therefore, my lord, my limit is that, my lord, within the limit I have purchased in, it was before selling.
What is the limit? How much quantity you can buy at one go?
2,000 bottles per month, my lord.
2,000 bottles per month.
Per month, my lord.
Okay.
So it is within the limit, my lord.
Going to the case diary, lordship.
So he's saying that he's a purchaser, legalized purchaser as in terms of the license given.
Yes, he's
So
already.
he's not into kind of smuggling or transporting or activities which are prohibited under the NDPS
But
Act.
yes, but.
So that is what he's saying. And like if he's a licensed distributor or dealer, how he can implicate him?
But his father was arrested.
No, what is there in the CD? You see,
That documents, the GST and other documents are not in the case diary, lordship. If he is a licensee holder, then this should be in the case diary. His father was arrested. He is also a partner of the business, lordship. He's from his godown. This contraband was recovered and seized.
no, There must be something,
he-
no, why he's
he's
saying that upon arrival, he was two
He is
persons.
absconding till from the date of incident, Lordship.
Hmm.
His father was arrested.
1 second.
Not absconding, my lord, I am before my lordship, my lord, seeking protection of pre-arrest bail. So under such situation, my lord,
Who is Sahid Ahmed Borbhuya?
my father, no? Myself, my lord, Sahid Ahmed Borbhuya is the petitioner number 1, my lord.
And Sahid, and then
And petitioner number 2 is my employee, my lord.
petition number 2 is your employee.
My lord.
Hmm.
And even he is not named in the FIR also, my lord. My lord, it is a clear case, my lord. My father had been arrested basing on this affair, suspecting that we are dealing with this, my lord, narcotic drugs, my lord. And even my father had also been enlarged on bail by the learned trial court below, basing on an order, my lord, 23/6/20.
And who is the license holder?
I am, my lord, myself. My lord, kindly verify my license, my lord.
You are the license
My
holder.
lord.
And your father has been arrested for what then?
At that time, my lord, we don't know, my lord, they come and picked up.
Now,
my
where is the
father.
order of your releasing your father on bail?
Yes, my lord, this is the order, my lord. I'll copy next. I'll do this. Yeah. It will be like also.
Complementary recover ফাঁকাটা ঢুকে
Hmm?
Affect to have license কম করেছে
33, page 30.
বাপের কোন নাম উঠে আসছে
33.
কোনো আবদা বলেন
Sahid Ahmed Borbhuya. Name, petition number. Huh? Oh, my lord, my respectful submission before my lord is that, my lord, when there is a case, my lord, that the police has the power to arrest or investigate or carry on. Now, my father was there, he could be arrested. Now, my lord, whether, my lord, this categories falls within the contraband as alleged by the, my lord, the prosecution, that is, according to the various documents and the, my lord, which we have got, it do not fall. That's why, my lord, the license and as well as nobody can purchase any such contraband by giving GST also, my lord. If it is an illegal drug. That to such a huge, my lord, number, because I am a distributor, wholesale distributor, my lord.
You are a distributor or you are a pharmacist?
My lord, my lord, kindly.
Where is your trade license?
License, my lord, this is the license.
And where is the copy of your, consignment, that invoice for the consignment?
Purchasing, my
Huh?
lord. Yes, my lord,
And first come to the license, where is
license at annexure 3, page 33, my lord, license to sell, stock or exhibit or
1 second, 33.
page 33, annexure 3, my lord.
Hmm.
License to sell, stock or exhibit, they sell or distribute the wholesale drugs specified in Schedule C and C1, excluding those specified in Schedule 10 under the Roman, my lord. So, Mr. Sahid, medicine store is hereby licensed to sell, stock or exhibit or offer for sale or distribute by wholesale on the premises situated at so and so, Udarban, post office Udarban, so and so tax, specified schedule and C1 excluding. So, my lord, this is the categories and detail had been written here. So this license is perpetual, not even required for the renewal also, my lord. If I follow the terms and condition, is at page 34 is the perpetual order, my lord. And now, my lord, can verify my purchase at page 38, annexure 5, my lord, from MS Simran Pharmacy, my lord. Exact number of bottles which had been seized and exact number of.
Page 38.
Page 38, my lord. This is, my lord, that serial number 2 is the 1200 and serial number 5 is 220. My
No,
lord.
this is, I mean, this is the GST invoice, right?
Yes, yes, my lord.
Purchasing.
Purchasing, my lord. Only after the purchase and delivery, my lord, they will give.
Now, is there, is there any quantity that has been mentioned that you can buy this much of quantity only per month?
Yes, yes.
Because I mean.
My lord,
What is it?
we have also verified that, my lord, there is a notification and circular for this type of drug distributors that in a year or in a month, how much, my lord, bottles can be, business can be done. My lord can find that notification, we could not find out, but that notification find a place in this honorable court's order, my lord. I am, my lord, bringing my lordship's kind notice to this order, my lord, also, my lord. My lord can verify from paragraph 18 below. $2,000 bottles per month, and further a retailer can have 100 bottles. So now, my lord, as I am a, my lord, CNF and CFA, my lord, so I can have, my lord, this 2,000 bottles per month, but it is, my lord, very less than that quantity. And basing on this argument, my lord, my father had been came to be enlarged on bail by the learned.
No, your father's this thing was that bail was because it was not named in the, it was not, license was not in his name.
That is correct.
His,
that is
he,
correct.
and he has specifically stated that the son, his son has brought
Yes.
all those things. On
My
the
lord,
basis of that.
I am not denying, my lord, I am not denying.
No, not on the basis of this, your father was given granted bail. Your father was granted bail because he was not the person.
That is correct, my lord, but this submission has been advanced, my lord.
Submission has been advanced. As
Right.
submissions, thousands of submissions can be made, but the court has considered one submission, that is, so on the basis of that, he has been granted. Yes, Mr. Goswami, it seems like he has a valid license, okay?
But that document should be in the case diary and to the produce should be it should be produced before the investigation officer. The documents in their hand.
No, see, I mean, that trial thing is there, but like, I mean, prima facie, I'll have to consider this his bail application. For consideration of the bail application, he'll have to tell me. Because see, he is bringing on record that he is a CFA agent. He is a dealer.
Yes.
And he has this license to store this and sell this. And he has given an invoice also that he has bought this much of bottles from one Samiran or whatever, Simran Pharmacy in Manipur. But I don't know why they are buying it from Manipur and shop it as is in Kachar.
Maybe due to distance, my lord.
Hmm?
From Barak Valley area, Manipur is nearby, my lord. So via Silchar, my lord, cutting the cost.
Only the statements of his father is here and FSL report also positive. It was choline phosphate.
The positive part is this is a prescription drug, no?
Yes.
This is a prescription drug which is available, I mean, in the market. You can buy it. It's not a heroin. It's not heroin, or it's not something which is totally illegal. This is a prescription drug. You can buy it, and he has license to store it.
Other than that, what it does,
And specified in Schedule C and Schedule C1. Okay, in this invoice,
My,
where are those?
my lord,
One Vincoff is there. Vincoff, you bought
150, my lord, serial number
serial number 2.
two is 1200 quantity bottles, pack of 150 my lord, that is Vinco Plus.
Yeah, Vincoff Plus is there, 150.
My lord.
But
And
what about the other one?
Secondly, my lord, serial number 5, 220 bottle, my lord, a pack of 120, it is PBRX syrup.
And that has been seized. That
Yes,
that much has been.
it same quantity, same product has been seized, my lord. In the seizure list also, my lord can verify, my lord. That is
I prefer lordship, if lordship allow me to take instruction regarding the investigation of officer lordship for 1 day lordship. If anything comes up, because it is a NDPS commercial quantity lordship.
What instruction, my lord, we have, my lord, we will cooperate, my lord, we will go
But
and
that
whatever
documents
is
is
there,
not
we
in the
will
case
cooperate
there.
with the investigation, my lord. Even all the documents, my lord, which I possess is required to be submitted before the IO, my lord. If my lord protect me, I will cooperate with the investigation. I will go, my lord, and submit all those. The clear case of, my lord, medical business, my lord, pharmacy business. Had I been a retailer, my lord, then there is a, my lord, doubt may arise that why so much of huge quantity, my lord. But I am a wholesale distributor, my lord. And my lord can verify, my lord, is at page 30 is the relevant part of the seizure list.
What is there in the CD? Is there any material in the CD?
Material regarding only on seizure list and statement of his father lordship as the accused. And other things are FSL report and procedural things which is done in the NDPS Act lordship. Other things, there is nothing again other than that lordship.
Then how can you, I mean,
But that document should be in the CD, but that document should not be in the CD.
okay, we'll come back at 2 o'clock. We'll pass the order.
My,
Yes, Goswami?
Let him produce the documents before the investigating officer, and I will verify the documents and later on, Lordship will.
What documents?
This, what does the ST certificate and license, all the documents? Yes. Let him produce the documents before the IO. And after the CD, any CD Lordship call for, then after verification, it will come out, then.
Right, heard Mr. A.R. Bhuya, the learned senior counsel assisted by so-and-so. Appearing for the accounts applicants, also heard Mr. D.P. Goswami, the learned APP for the state. This is an application on the application under section 482 of the BNSS 2023, praying for granting anticipatory bail to the accused applicants in connection with Udharban PS case number 45/2026, registered under section 22 in bracket C, small c, stroke 29 of NDPS Act 1985. The brief facts of the case are that on 4/6/2026 at about 1 a.m. complaining, namely SI Kalidhar Thousand of Udharban PS lodged an FIR before the Udharban police station to the effect that on 1/6/2026 about 12:15 p.m. on receipt of one telephonic information by the officer in charge Udharban police station, namely Inspector SI Singh Timung, regarding concealment of suspected NDPS substance by one Sahid Ahmed Borbhia and his father Azizul Haq Borbhia in their godown located near their house. Accordingly, the information was entered by Udharban PS GDE number 09 dated 1/6/2026. And thereafter authorized SI Kalidhar Thousand to conduct search and seizure at the godown of Sahid Ahmed Borbhia and Azizul Haq Borbhia. The police team went to the place, that is Durganagar Part -5, Roman 5. And two suspected persons, Durganagar Part 5, along with the required witnesses. Upon arrival, they found two persons identified themselves. They found one person namely Azizul Haq Borbia. Full stop. Upon search, in the premises, the police team found 9 cartons and some loose bottles of suspected NDPS substance, in bracket codeine cough syrup, calculating a total of 1420 bottles. Next paragraph, details of the seizure are as follows. Eight cartons of tripyrrolidine hydrochloride and codeine phosphate syrup of 100 ml bottle. Batch number in capital TBHZ0039, comma, MFG date 04/2026, 04/2026. Brand name Vincof, VINCOF plus, Vincof plus, comma, each carton contained 150 bottles, totaling 1200 bottles. This is number one. Huh? Number two, codeine phosphate tripyrrolidine hydrochloride syrup, batch number HLA37, MFG 12/2025, brand name PBREX of 1 carton containing 120 bottles, comma, 1 packet containing 100 bottles, totaling to 222 bottles. Number three, 1 Realme mobile handset. The police apprehended the aforesaid person and taken in custody. During investigation, the apprehended person intimated the police team that Sahid Ahmed Borbia has brought the suspected NDPS items and kept in their godown, and they ran a pharmacy together. Next, on receipt of the FIR, the police registered the Udharban PS case number 45/2026 under the aforementioned sections. The learned senior counsel appearing for the accused applicants submits that the accused applicant number 1 is the owner of a wholesale wholesale medicines shop having license to deal with medicines, including the seized medicines. Also, he submits that accused applicant number 2 is a person working with the accused number 1's concern. Also, he submits that accused applicant number 1 is a license holder and his license holder to sell issued by the state government of Assam in bracket form 21-B to sell stock or exhibit in bracket or offer for sale, SALE, sell or distribute wholesale drugs specified in schedule C and C1 in bracket 1. One is Roman 1 bracket excluding those specified in schedule 10. He submits that the accused applicant has his business concern, namely Messrs. Sahid Medicine Center, which is duly registered under the Government of India authorities for GST and he is having a trade license for doing his business. He further submits that the seized goods have been bought from a pharmacy located in Manipur, and the invoice of the aforesaid medicines is also duly issued to the accused applicant by the pharmacy concerned. He submits that the police has already seized the items and necessary documents of his business concern has already been annexed with the instant application. In view of the aforesaid, he further submits that the accused applicants further, namely Saiful Haq Borbia, who was arrested by the police from the place of from the godown, has already been granted bail Which court has granted bail?
Learned,
Granted bail by
Lord, by the learned aspect. Lord, I will provide the name of the honorable court, my lord. This is from the order sheet actually we have received, my lord.
granted bail in GR case number 807 of 2026.
Special Judge Kasar.
Special Judge Kasar.
Special Judge Kasar.
Special Judge Kasar.
Yes, sir.
In connection with this by the learned Special Judge Kasar. In view of the aforesaid, the learned senior counsel submits that the accused since the accused applicants are doing the business legally, and the seized items were not meant for any kind of smuggling or illegal use, the accused applicants should be granted bail granted pre-arrest bail at this stage, since they are apprehending arrest. Full stop. The CD in the instant case has been produced, and the same is perused. Mr. DP, the learned APP, DP, Mr. DP Kuswami has opposed the bail, opposes the bail, prayer of bail to the accused applicants. Full stop. Next paragraph. This court has heard the submissions made by the counsel appearing to the respective parties and have also perused the documents annexed in the instant anticipatory bail application. It is seen that it is seen that the accused applicant number one is having a license to sell, stock or exhibit or distribute wholesale drugs specified in Schedule C and Schedule C1, excluding schedule those specified in Schedule 10. These drugs are under which schedule? Schedule C.
Category H, my lord.
Hmm?
Category H.
Category H mentioned in which schedule? Schedule C. NDPS.
Either is told for the action. It's done.
Where that can be found? Caesar list no mention is there.
Caesar list no mention.
Lord can verify from this, the drugs and cosmetic rules of 1945, my lord. Schedule H1, serial number 20, my lord. Kindly have a look.
Now here it says about C, your license is for Schedule C, C1 and X.
My lord can find it.
Schedule C and C1.
My lord, from the license.
Hmm.
My lord, kindly turn to page 34, my lord.
Yes.
This is the continuation of the license.
Correct,
License to
correct.
sell, stock or exhibit or offer for sale or distribute the wholesale drugs other than those specified in Schedule C, C1 and X. This is the continuation of my original license, my lord.
But it says this page 33 says license to stock, exhibit
My
or
lord.
offer, sale, distribute wholesale drugs specified in Schedule C and C1.
My lord, kindly turn to page.
No, then again, how can it be, I mean, totally opposite, other than? See, it says that like, I mean, whichever is we have been mentioned in Schedule C and C1.
My lord, only excluding the X particular.
Only excluding, it has
X.
been, it
My
is
lord.
there in page 33.
My lord,
But page 34 says
my lord.
license, stock or exhibit so and so, drugs other than those specified in Schedule C, C1 and 10. What does it mean?
And X, my lord, that it
Yes,
does mean then, my lord.
what does it mean then? It goes totally opposite of page 33.
No, my lord, it is not license to sell, stock or exhibit or offer for sale or distribute the wholesale drugs specified in schedules.
Correct.
C and C1.
C and C1, correct?
Correct.
So whatever is named, I mean, in the C and C1, you are licensed.
My lord.
But in the other document 34, it says license to sell, stock or so and so or distribute sale other than those specified in C and C1.
No, my lord, this, both the license has two different meaning, my lord.
What
Different
meaning?
Because the first one says, my lord, that the C and C excluding those specified in Schedule X.
Yeah.
So now this has a meaning, my lord, it independent meaning of itself, my lord. Now the second license, my lord, which I do have, as said, my lord, those specified in Schedule C, C1 and X.
Correct. So, I mean, this document 34.
Well, document 34 has given me the license to Schedule C and C1, my lord. And the document contained in the license, my lord, in the next page, my lord, schedules sell drugs other than those specified in Schedule C, because this is the supplement to the next.
Okay, understood. Now,
Now-
understood. Now, I mean, show me where is Schedule C or C1 or what? From where, I mean, this drug can be found?
My lord, this is the H, this is the Assam because it will come under the drugs and cosmetic rules, my lord. Schedule H is the codeine, it has been defined there, my lord. So we are not, my lord, selling any kind of, my lord, NDPS particles, my lord. It is under the drugs and cosmetic rules, my lord. My lord, if we go by this, another order passed by this honorable court, my lord, clarifying this also, my lord. My lord, may I place this order, my lord? Yeah, exactly on same footing, my lord, this honorable court has constituted these categories of license, my lord. My lord, page number, my lord can find it from. Relevant part to the. My lord can kindly turn to page number 6, my lord. I am reading from, my lord, by the two licenses issued in favor of the petitioner. By one license, he was permitted to stock or sell oblique distribute drugs by retail other than those specified in Schedule C, Schedule C1 and Schedule X. And by the other license, he was restricted by the license to sell, stock or exhibit retail drugs specified in so and so to the vendors. But the cough syrup falls under the Schedule H drugs, and thus it is seen that the petitioner was not prohibited or restricted to sell the codeine phosphate cough syrup, which was found in the conscious possession of the present petitioner during search and seizure. However, it is a fact that the petitioner could not produce the receipt of the time his arrest, it was, my lord, at the time of arrest petition was there, my lord, and this is a pre-arrest bail application.
And you are not making any statement also who has issued these licenses, who has issued these licenses?
Milord,
Which authority?
the drug licensing authority. Sir.
That was, where have we made a statement? Your document also doesn't reveal who has issued this certificate license.
No, Milord, this license has not been doubted or denied by the any.
No, not forget about doubted or denied. I am asking you, a court has to be convinced. I mean, you are not making a statement who has issued this license, and you are not able to point out that, which are the C scheduled drugs? Which are the C, I mean, you are saying that you have been given a license, right?
My lord.
Now, a license has been given to you to stock, sale, or offer, under Schedule C.
My lord.
Now, like, we want to know whether under Schedule C or Schedule C1, the drugs that have been seized from you, whether they appear or not, whether those drugs are scheduled there or not. But from where, I mean, you are not able to show it. You are showing something under
No,
drugs
Milord,
and
because these are under the, Milord, the category H drugs, Milord, under the cosmetic rules.
category H drugs, I
Schedule H,
understood.
my lord.
Understood. Then what is the purpose of giving this license then?
No, purpose, Milord, as per
The purpose is, see, if it is category H
Well, I
drugs,
can understand.
see, understood, Mr.
My-
Bhuya, try to understand.
My lord.
If it is a category of H drugs under the drugs and cosmetic rules, then this is not required at all.
My lord.
It will be under drugs and cosmetic rules.
My lord.
So, I mean, this is not NDPS. So your argument would have been different altogether. Isn't it?
My lord.
Your argument would have been totally different. NDPS is not, NDPS cannot be applicable to this case. Your arguments would have been totally different. Now, thing is that you are showing me these two licenses, right?
My lord.
Your bona fide is not doubted. You are showing some two licenses.
My lord.
But now you have been given license to sell, stock certain drugs. Now you need to show me, just simple thing is that you have to show me that like that drug features in this schedule.
Schedules.
So that is what we want to see.
That schedule, my lord, want to see.
That's what we want to see. I mean, if that drug is there, then of course, I mean, like, you are licensed to operate.
Do
There
the
is no
business.
problem then.
Do the business.
I mean, we are convinced with your that argument only, but
Fine.
now while looking into it, I mean, there may be, but I think that is not available with you as of
Fine,
now, right
fine.
now.
My lord.
So you'll have to show me because H is fine. H is
Codeine.
yes, H schedule is under the drugs and cosmetic rules.
My lord.
So that is different. That is not, all these things are not NDPS. But here the applicability is
No,
NDPS.
I have understand my lordship's
Hmm.
query. My lordship wanted to know that under this schedule C1,
Huh.
which are the drugs are enlisted.
Correct. So
under
that schedule. Like we can verify that
Fine.
verify that the drugs which have been seized,
My lord,
those, I mean, for that license has been given to you.
given to me.
Given to you. Otherwise, this document doesn't have any value.
Yes, my lord, because it excludes this, my lord, the drug which has been seized. If it is not within the schedule, then there is an offense, my lord. Under the-
Correct.
Under the drug and cosmetic.
Understood. No, that is what
Fine.
we wanted to verify. Because if you are allowed to stock these drugs, then there is no problem. You have a license. You have a proper invoice.
My lord.
Those are not doubted. I'm
Fine.
not doubting those. But the only thing is that to verify whether
schedule, my lord.
whether in the schedule, because for the purpose the license has been given,
My lord.
whether those drugs are there or not. Now, Mr. Goswami, do you have any material on this?
No material, Lordship, because the documents is not in the case diary, Lordship.
Verify these schedule C drugs, which are.
See, you have been given license
My lord.
for Schedule C and C1 drugs,
My lord.
and that excludes those specified in Schedule 10.
Correct.
This is your license, correct?
yes.
Now, the first license is that. The second license says that it license to stock, exhibit, sell, distribute drugs other than those specified in Schedule C, C1. Maybe C1 is separately given or
Right.
this has been separately given.
Correct.
That is true. Now, thing is that licenses doesn't say who has issued this license under which rule.
My
I mean, this license may not contain all those details, but
Exactly.
at least statements
lord,
would have
my
been made.
statement
Statements would have been there that this
Yes,
has been issued under this
That I
rule,
have made, my lord.
so that we could have verified.
No, my lord, that is our, my lord, inadvertent bona fide
Correct.
mistake. That
So
will
now
be-
thing is that now we are unable to verify now under which.
No, my lord, our case is very, my lord, very limited, my lord, that whether the whether the, my lord, contraband, illicit contraband which they have seized, these NDPS materials, my lord, whether it comes within the purview of this NDPS. My lord, as per the schedule H, my lord. which I
That
have
is what,
annexed, my
that
lord.
is what we are
Lord,
saying also.
Our
We are-
case is
no,
that
we are,
there is no
we are,
nexus with the
no,
NDPS.
we are saying, see, I mean, if you are given a license to keep those drugs, there is absolutely no problem.
My lord.
But only thing is that we need to verify whether those drugs are there in the schedule or not. And whether the license has been given for codeine or not, or license has been given for something else, but you are keeping codeine. This is what the concern of the court,
My
because we are unable to find out from here. You take the instructions and come up tomorrow, we'll list it tomorrow.
My lord.
So we'll have to verify. NDPS case a large
Yes.
amount, huge amount. I mean, you have an invoice. I'm not doubting that.
My lord.
You have license. We are not doubting that. Only thing is that some verification needs to be done
My lord,
before passing an order.
Only thing is that, my lord, prima facie, my lord. Prima facie, if I, my lord, place my case, my lord, that the documents, the license, and well as the invoice. My lord, nobody will execute an invoice for such a huge quantity if it falls within
See,
the
that
category.
we are not commenting on that because
My
we
lord.
do not know, we do
My
not know.
lord.
Because you also cannot say that nobody, these kind of invoices can be given by anybody. That, let me tell you one thing.
My lord.
That you also know about this.
My lord.
So, but I'm not doubting that. This can be done, but I'm not doubting this because you are stating, so you are stating in an affidavit. You are saying so by way of an affidavit. I'm not
Right.
doubting that. Only thing that we need to verify this.
Schedule C, Schedule C one.
But you just go through this, you'll find out that you have been given license for certain products, right? Which have been, which were in, which is there in the Schedule C and Schedule C1. Now, you just need to point out that in Schedule C, Schedule C, this drug, which has been seized from you,
My lord.
that features,
Also
features
in Schedule C, my
it is found in Schedule C.
Right.
Then your case is, I mean, case is absolutely clear.
lord.
So that is what you need to find out and
My
like.
lord, keep this as a part heard, my lord.
No, part had not required. Tomorrow I'm sitting, tomorrow I mean, we'll listing it tomorrow. We are listing it tomorrow. You bring that instruction and
Yes,
find out.
yes.
You just assist me like where to find
No,
out
no, my lord,
this.
it is my duty
Correct.
to assist.
Because NDPS Act doesn't contain that. So that schedule doesn't contain. It must have been issued under particular some, maybe, some notice, maybe some official memorandum, or maybe some
That is
rule
my lord.
made under the NDPS.
Rule is mentioned in the license, my lord.
No,
That will verify.
the rule is mentioned is license where?
My lord, it is Form 21B, C Rule 61-2. Now, what
Rule
rule?
60, which rule?
Which rule it is not there?
Then
Cosmetic rule.
61, there will be thousands of 61.
I will place all the material.
Correct. Heard Mr. You cut those things, just keep it like that. Tomorrow we may require this. You just write on the prayer of Mr. A.R. Bhuya, the learned senior counsel, the matter is adjourned to tomorrow. The matter is adjourned today and to be listed tomorrow.
My lord.
Right. Take it as it is.
Sir, it's not submitted, it's pending, Lordship.
Hmm?
Council not submitted, Lordship, it's pending.
This 60 days.
60 days.
Lordship.
Okay. Heard Mr. R.
Yeah.
Ali,
H.A. Ahmed.
H.A. Ahmed, the learned counsel appearing for the accused applicant, also heard Mr. D.P. Goswami, learned appearing for the state. This is an application under so and so. Then you write,
Similar order at GS 24.
the matter relates to transportation, illegal transportation of cattle, which were seized by the police on certain specific information. From where those were seized?
From vehicle, man.
Hmm?
From my vehicle.
Huh?
Vehicle.
Where, place?
Place by the
Lakhipur?
Lakhipur.
Hmm?
Lakhipur.
Near Dhamor Bazaar, Lakhipur. On receipt of the FIR, police registered Lakhipur PS case number 79/2026 under the aforementioned sections. The accused applicants were arrested on when you were arrested?
21/5.
21/5/2026 and 2026 full stop. The learned counsel, depending to the accused applicant, submits that the accused applicant has already spent more than 60 days behind the bars and therefore they are eligible to get, to be released under default bail. Full stop. Mr. Mr. DP Goswami, the learned APP submits that no charge sheet has been filed till date, full stop, taking into account the aforesaid submissions, the submissions, and since the accused applicants have already spent more than 60 days behind the bars, this court, behind the bars, and therefore they are eligible to get default bail in the instant case, are directed to be released immediately on furnishing of bail bond of rupees 20,000 each to the satisfaction of
CGM Golpara.
CGM Gwalpara, subject to the condition that that the accused applicants shall cooperate, applicants shall cooperate with the investigation and make themselves available as and when required. Full stop. In terms of the aforesaid direction, the instant bail application is disposed of as allowed.
Anticipatory bail application, my lord. The lordship kindly see, my lord, petitioner before your lordship, he is not name accused, my lord. The lordship kindly seek FIR page 13, my lord. Page 13, my lord. He is working as a statistical and planning officer of the education department, and he is going to retire after 7 months. And this FIR was lodged, my lord, on 27/6/2026, my lord. The lordship page 13, my lord.
Yes.
Only total FIR is, my lord, against only one, my lord, Middu Pawan Das.
One second.
Your lordship kindly see on the basis of the one, there is a line, man, in the last para of the FIR, my lord.
One second.
My lord.
Okay, allegation is against one Middu Pawan Das.
Your lordship kindly see the last part of the, my lord, FIR, my lord.
Mm.
Very last line of the last but one para. And that's
Is an internal inquiry going on?
That internal going on, that above that, my lord. So that internal inquiry going on, my lord, that is, my lord, that will reveal everything, my lord. But no, the document for several private school Nagaon district, as well as against all the other individual involvement for taking in this line, my lord, the entire office, my lord, police call, police interrogated. I am ready to interrogate it, my lord. I am going to retire after 7 months. If I am arrested, my lord, it will be.
You are working as what?
I am working as a statistical and planning officer.
Statistical and planning officer where?
In Nagaon, my lord.
Which department?
The education department.
Education department.
So that is my case, my lord. Now, if, my lord, anything reveal in the case, there your lordship cancel my petition, my lord. But, my lord, your lordship problem is that, my lord, in fact, my lord, I went to the police station and deposit all this record before this police, my lord. Police also questioned me also. Now, my lord, entire office is in a afraid. So your lordship kindly call for the case there, my lord. If anything material there, my lord, then your lordship cancel it.
My lord, if already went to the police and submitted document, police has
Not submitted document, sorry, what I'm submitting. I was sent by the inspector of school to produce the document, and I have produced, my lord. So even then, thereafter, my lord, he questioned me and telephone and he asked me to the police station, my lord. So that is my case.
I heard Mr. T.J. Mohanta, the learned senior counsel, appearing for learned senior counsel, assisted by Ms. M.K. Brown, the learned counsel, appearing for the accused applicant. Also heard Mr. K.K. Parasar, the learned AP for the state, decent application under section 482 of VNSS 2023, claim for granting a disability bill to the accused applicant in connection with Nagaon PS case number 496/2026, registered under section 1/2/336/3/338/340 of BNS Act 20223. Then you write the facts leading to filing of the anticipatory bail application are that an FIR was lodged by one middle command
Inspector of
of schools, Nagaon, before the officer in charge, Sadar Police Station, Nagaon, alleging that certain schools in the jurisdiction of Nagaon district, under the jurisdiction of Nagaon districts, have been submitting certain documents such as prior permission, provisional registration, dice code and severed code documents. Documents for these are submitted for what? This is for
For a dias code, my lord. That dias code.
No, you write
To
like
say
this.
that his signature is for it.
I write like this, that certain schools under the Nagaon district have been submitting certain documents to procure the DICE code. DICE is DISC or DICE?
SC.
DISC, no?
SC.
Not that DICE.
Not dice. Dice.
DICE code. DICE code. Forging name, along with certain false documents, full stop. Being suspicious of involvement of one Mridu Pavan Das. The instant the instant FIR has been lodged, and it has been stated it has been mentioned in the FIR that internal departmental inquiry is still going on. Full stop. In view of the FIR, the police started investigation. Next one, in view of the FIR, the police started investigation, and during the investigation, various documents relating to several colleges have been submitted. Full stop. The learned senior counsel appearing for the accused applicant submits that he is a statistical officer.
Statistical and planning officer.
Huh? He is
Planning and statistical
He is a
officer.
planning and statistical officer.
There are two I've said.
Posted in Nagaon. Posted in Nagaon.
Nagaon, man.
Posted in Nagaon, working under the education department of government of Assam. He submits that the accused applicant is not involved in any kind of forgery that has been alleged in the affair, and he is going to retire within
February 2027.
in 7 months of time.
7 months.
In 7 months' time. He further submits that he being a responsible officer, he will fully cooperate with the investigation in the instant case. Full stop. Therefore, he submits. He prays that at this stage at least he should be granted some protection, some interim protection. Full stop. Taking into account the facts of the case and on perusal of the documents that have been enclosed along with the anticipatory bail application, this court is of the opinion that the accused applicant should be granted some interim protection. Full stop. Accordingly, it is directed that in the event of arrest of the accused applicant in connection with Nagaon PS case number 496/2026 by the arresting authority, he shall be released on furnishing, or he shall be released on interim PRS bail on furnishing of a bail bond of rupees 50,000 along with the security of like nature, subject to following conditions. Number one, subject to the condition that he shall appear before the investigating officer within a period of 7 days from passing of this order and shall cooperate with the investigation. Full stop. Next para, court call for the CD, later matter be fixed on
5th of August, madam.
5th of August.
Develop.
Mr. কিমান মিটাৰ আছে ন অৰ্ডাৰ এটা পাছতে অলপ সময় লাগিব কিমান মিটাৰ বাকী আছে মোৰ কেইটা
I was seeking another date, madam, CD not received.
Heard Mr. J. Ahmed, learned counsel for the accused applicant, also heard Mr. K.K. Parasar and APE for the state. CD not received, later matter be fixed on first week.
Morigaon, madam. 28, madam.
28, later matter be fixed on 28th of July.
Customer number 2 notice.
No, service report I have written, madam. I'll obtain the instruction, madam.
Service is not complete. The right and service is also not complete. Service of notice on respondent number 2 is also not complete. Is
59.
not a hearing. Bail hearing.
Anticipated bail application in terms of
Oh, bail- bail-
interim order dated,
Clear, madam, yes.
interim order ballot passed on 22/6, I have appeared before the IOM.
APR my statement recorded.
Okay. Heard Mr. P. Hazarika, the learned counsel appearing for the accused applicant, also heard Mr. K.K. Parasar, learned APE for the state. Then this is an application under section 482 of BNSS 2023, granting PRS bail to the accused applicant in connection with Silapathar PS case number 98/2026 under sections 325/232/238 of BNS 2023, read with section 13 of the Assam Cattle Preservation Act 2021. The learned counsel, the accused applicant has been granted interim pre-arrest bail by order dated 22/6/2026, and it has been submitted that he has already appeared before the investigating officer in terms of the aforesaid order and got his statements recorded. Full stop. In view of the aforesaid, the learned counsel appearing to the accused applicant submits that the interim pre-arrest bail granted to the accused applicant should be made absolute. Mr. K.K. Parasar, the learned APP has received APP has produced the case diary and the same is produced. Mr. K.K. Parasar submits that confirms that the accused applicant has already appeared before the investigating officer and got his statements recorded. In view of the aforesaid, the interim pre-arrest bail granted by the order dated 22/6/2026 is made absolute and in the same terms and conditions as mentioned there, and the instant AV application is accordingly disposed of.
61, madam, charge sheet submitted.
Heard Mr. Amar Khandakar, the learned counsel appearing for the accused applicants, also heard Mr. K.K. Parasar and APE for the state. This is an application under section 482 of BNSS 2023, praying for granting pre-arrest bail to the accused applicants in connection with Gorikul PS case number 441/2025, under sections 189/4/117/2/329/1/2/304/2/351/2/351/3 of BNS 2023. The learned, Mr. K.K. Parasar, the learned APP submits that charge sheet in the instant case has been filed by charge sheet number
175/2026, dated 28/6/26.
Full stop. In view of the next paragraph, in view of the aforesaid submission, the learned counsel appearing for the accused applicant submits that liberty should be given to him to given to the applicants. How many applicants are there? Liberty should be granted to the accused applicants. Accused applicant, huh? Withdraw. Already I have, okay. Heard Mr. M.R. Kandakar, the London Council appearing for the accused applicants. Also heard Mr. K.K. Parasar, Learned AP for the state. Mr. Kandakar submits that he has instructions to withdraw the instant AB application. Accordingly, the instant AB application is dismissed on the 12th. According, next line, you know, Malik.
62.
62, sorry, Malad, CD not received.
CD not received, later matter be listed.
Lordship, as this is a case of suicide, Lordship,
Hmm?
I may be allowed to submit. This is a case of suicide, Lordship.
CD not received. Suicide case, we'll have to peruse this CD. And this is an order only on 13/7/2026 we have passed the order.
Lordship, but the petitioner is a government employee, Lordship.
Government employee.
Lordship,
Laluk, Malad.
Lordship is a assistant teacher.
Hmm.
And
Let us see the FIR.
FIR is at Lordship page 16 and the translated type copy is at page 13.
Hmm?
Page 13, translated type copy.
13.
Malad, within 5 years of marriage, Malad. Wife commits suicide.
Any suicide note?
No, Lordship.
No suicide note.
Lordship, the disease that the wife of the petitioner, she was suffering from a major depressive disorder psychosis.
Because of your torture.
Lordship, she was before marriage, Lordship, and she was
Is there any material on that?
Lordship,
Any
the
material of her suffering from this kind of disorder before marriage?
not before marriage.
Then-
Lordship,
Then after getting married to you, she became depressive. She went into depression.
Lordship, no.
Hmm?
Lordship, at the prescription at page 27.
Mr. Parasar, why CD is not there?
But no signal we have received. Malad. One chance may be given, Malad, on 28, Malad.
He's a government servant. He will, I mean, in case of his huge consequences.
From Laluk, Lakhimpur.
13/7 order was passed.
Yes, Malad, flood condition also, Malad, Dhemaji, Lakhimpur, physical city will come.
Then we'll allow them to go on interim bail.
Lordship.
Then
One chance, Malad, on Friday, Malad, then.
Friday.
Malad.
Finally,
If not,
petitioner-
Malad, then Malad.
Dream Lordship. If search sheet is submitted or if the petitioner is got.
But allegations are there, madam.
Within 5 years of marriage,
Allegations are there within 5 years.
torture and all.
But she was also suffering that.
Not that you cannot, you could not show that. I
If-
mean, see, somebody is suffering from mental disorder. That doesn't mean that she will commit suicide.
Lordship, the petitioner got to know that she was suffering from that disorder after marriage only. And he accompanied her for the treatment also.
No, I
We are
put them
giving,
at the very- very end, then, Malad.
giving an opportunity. I will
But
give,
on
we'll
Friday,
give you a short date, okay?
Malad.
Short date we'll give 2-3 days, not more than that. Mr. Parasar,
Malad.
on next Thursday.
Okay, Malad,
So next Thursday.
23rd.
Now don't tell me that you will not be available. This is an important case for you. How can you leave this case and go somewhere else?
Lordship, can it be on 22nd?
22nd, no,
22nd
tomorrow it will
short.
go, Malad, from Malad, Lakhimpur it has to come.
So,
Thursday or Friday, Malad,
okay, we'll fix it on 24th.
24th.
So till 24th, you'll have to take a risk.
Yeah, so-
Hmm? Yeah, because the allegations are quite, I mean, you have allegations are abetting of suicide, that too within, presumption is there under the act, within 7 years of marriage. All these things are against you. But still, we'll look into this. Okay, heard, MS?
C. Saikia.
D.
C. Saikia.
P. Saikia, the learned counsel appearing for the accused applicant, also heard Mr. K. Parasu, learned APE for the state. CD not received, let the matter be fixed on
24th.
24th. 24th.
Right.
24th, if we do not receive the CD, then we'll consider here.
Exit 3. This is an application for PRS bail, but as per section 43D subsection 4 of the UAP Act, Your Lordship, there is a bar. So I may be allowed, there is a bar in filing. So I may be allowed to withdraw and file appropriate petition with liberty to file appropriate.
Yes. Mr. Parasar, no problem?
Yes, yes, Malad.
Heard Mr. P.K. Sharma, the learned counsel, appearing for the accused applicant, also heard Mr. K.K. Parasar, learned APB for the state. Bar under what? What did you say?
Section 43
43
D subsection 4 of UAP Act,
UAP Act. There is a bar in AB, Malad.
similar to the SC/ST Act.
Okay, then you're right, Mr. P.K. Sharma submits that he has instructions to withdraw the instant application so that he can approach by just like that, like withdraw the instructions to withdraw the instant
With
application.
liberty to file appropriate application.
With the liberty to file an appropriate application, full stop. The instant AV application is dismissed on withdrawal with the liberty. So grateful.
Obliged.
But service complete, Malad. Amicus may be appointed.
When was it complete?
Recently. Service complete on 15/7, Malad.
15/7.
Yes, yes.
Then we'll wait for some time. We'll wait for another date. If nobody appears, then we'll engage somebody.
Yes, yes.
We'll appoint somebody. Heard Mr. F. Hawk, the learned counsel, appearing for the accused applicant, also heard K.K. Parasar and APB for the state. Mr. Parasar submits that service in the instant case, service of notice on respondent number 2 has been completed on 14.
Malad, today, Malad.
Today, completed only on today, that is on 20/27/2026. In view of the aforesaid, let the matter be listed on 29, 29? 29 July.
Admission.
Bills okay, bill order. Order first order is not 10,000. If bracket is order to pass over. Junior doctor data for. So I think
My lords.
it will take some time,
Yes, my lords, some other, yes.
but I think she has come from outside.
I think that's not this one.
Your lordship may extend the interim order up to 17th August because in some cases here is today, 18th August has been fixed.
Sorry, I didn't get you.
In another cases, honorable.
You just come to the mic, please.
In another cases, the honorable judge has given the time for 18th August.
18th August, similar case.
Not similar. She has some
Not
other
similar.
case. matlab
Or she has some other case.
She has some other
Okay,
case.
you can come on 18 August.
Yes, ma'am.
Okay, then we'll put it on 18 August.
Till then.
Okay,
interim order
heard
may be
MS
extended.
Singh, the learned counsel, appearing for the petitioners, also heard MS A. Gayan, the learned CGC for the state respondents. Okay, this matter was part heard.
Yes, part
You
of
will have to release it.
Yes, ma'am.
To release it. You can't
Your
keep it
lordship,
part.
Your lordship,
No.
there
No,
was-
I mean, see, there is a notification from Gauhati High Court that if within a month the matter cannot be, finished hearing, then the matter automatically, in fact, gets released. So we'll have to release this matter. So and so,
till then your lordship interim order is to end.
okay. the matter, the instant case is released from Parthar and registry to list the matter before an appropriate bench, full stop. Then you write, till then, the interim order so passed shall continue.
Masterclass.
One item, my lord, already gone, my lord, 62. But she has appeared, my lord. CD not present because of that, my lord, fixed on, my lord, 24/7. That teacher, my lord. But, my lord, it was listed for the first time on 13/7. It was adjourned. Actually, CD was not called. My lord, may kindly see, my lord, 13/7. CD was not called. Today is the first, the CD has to be called, my lord. The C has not also informed, my lord, we are also.
Visakya, you should have informed. CD is not called. You have taken an adjournment. This
Okay,
escaped my notice also. Okay, then you fix it on
Fix on 24/7.
24/7
CD has to be.
and call for the CD, yeah. Call for the CD.
If the
fix it.
CD,
I mean, I can't help it. I mean, last time you only took time. I don't know why you have taken time. 13/7. You are showing urgency, but like you yourself has taken time. See, clients are seeing everything.
Nowadays, my lord.
So you'll have to take care of yourself. Take time. Mr. Sharma, where is Sharma? Mr. Sharma will have to allow this. Hmm. Right, heard Mr. B.M. Chaudhary, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, the learned APP for the state. And this is an application under section 483 of BNSS 2023, paying for granting bail to the accused applicant in connection with fully board PS case number 56/2026 under section 143/61 in bracket 2/3 of BNS 2023, read with section 3/4/5/7 of Immoral Trafficking Prevention Act 1953. 53, full stop. The facts leading to filing of the instant bail application that on 15/6/2026 on 26 upon receipt of certain certain information regarding organized prostitution racket being operating from Hotel Orbit, the same was entered in GDE number 216 dated 15/6/20. The same information was entered in GDE number 216 dated 15/6/2026 of ISBT PP, and the same was communicated to the senior officers. Accordingly, a search and raid operation was conducted from 1900 hours to 2100 hours under the leadership of Sri Abhishek Kumar Yadav, APS, additional SP in bracket crime Jorhat, assisted by Srimati Debolina Bhattacharya, Deputy SP, DSP, Deputy DYSP, Deputy SP, SI Akash Gogoi, SI Punmoni Gogoi, SI in bracket P Pooja Hazarika and other police personnel. It was alleged that during the raid, the police teams searched different rooms of Hotel Orbit and found 7 women and 8 male persons under suspicious circumstances, indicating their involvement in the prostitution-related activities. It was also alleged that several articles suspected to have been used in commission of the offense were also recovered and the same were seized by the police in presence of witnesses. It was stated that as the operation concluded after the sunset and the arrest of female accused persons were considered necessary for proper investigation, permission under section 43 in bracket 5 of B and SS 2023 was obtained from the Judicial Magistrate First Class. After the women were apprehended. No, don't write and then the women were arrested. The don't cut that line, no? Last line. Then you write. It was alleged that during the inquiry and preliminary investigation, it transpired that the accused, number one, right, accused in bracket like right, 1, Dabulina Pegu, 2, Ranjuti Das, 3, Manasi Das, were actively associated with the prostitution racket and were engaged in procuring and calling women for prostitution activities and facilitating customers at Hotel Orbit for commercial sexual exploitation. The remaining women found during the raid were prima facie suspected to be victims exploited in the immoral trafficking network, and their statements were also recorded during the investigation. It was alleged that the accused persons and other associated persons involved in facilitating, organizing, and operating prostitution racket. On next para, on receipt of the FIR, police, receipt of the FIR, Pulibor Police Station case number 56/2026 under the aforementioned sections was registered. Next para, the instant application has been filed by the accused applicant who has been arrested on 16/6/2026, and since then she is behind the bars. The learned counsel, Mr. B.M. Chaudhary, the learned counsel appearing for the accused applicant, submits that the whole raid and arrest conducted by the police authorities in the instant case is illegal as the mandates of the statutory mandates of were not followed while conducting the raid as well as arrest of the accused person in the instant case. He submits that under the Immoral Traffic in bracket Prevention Act 1956, the power for power for raiding and arresting a person, mm, has been given only to a special officer who has to be specifically notified by the state government for a specific area. He submits that in the instant case, the raid and conduct, raid and arrest of the accused person was done by a person, done by a police person who who is not uh, who is not notified, who is not a notified special police officer under the aforesaid Act of 1956. He submits that in view of such failure or non-compliance of the mandate of the provisions of the Immoral Traffic Prevention Act 1956, the 56, the whole arrest of the accused applicant has become illegal, and the same gives an unfettered right to the accused applicant to be released on bail instantly. Full stop. Next para. During the course of hearing, on an earlier occasion, that is on 14/7/2026, this court has specifically inquired from Mr. B. Sharma, the learned APP, appearing for the state, as to whether the raid and arrest in the instant case, the raid of the premises and the arrest of the accused applicant in the instant case has been done in terms of the provisions of the Immoral Traffic Prevention Act 1956 or not. Some time was granted to the learned APP to complete his instruction about the aforesaid issue. Now, it was specifically requested to the learned APP to get the information regarding appointment of regarding whether the police concerned involved in the raid and arrest in the instant case was notified as a special police officer under the Immoral Traffic Prevention Act 1956. Full stop. While the case was taken up today, Mr. B. Sharma, the learned APP, has fairly submitted that he has been provided with some instructions. That is an order issued by the Senior Superintendent of Police, Jorhat, dated 21/2/2026. But the same does not specifically reflect whether the same has been issued in terms of the provisions of the Act 1956. That will do. 1956. Full stop. The instructions, the order, the aforesaid next para, the aforesaid order dated 21/2/2026 has been produced before this court, and the same is kept on record, marking X. This court has heard the submissions made by the counsel appearing for the respective parties. Full stop. Yeah. Before going into the facts of the instant case, it may be relevant to, it may be relevant to, it may be relevant to discuss discuss the provisions of section 13, section 14, and 15 of the aforesaid Act 1956 for the convenience of the court, for the convenience, the aforesaid provisions are extracted herein below. Just write this, 13, 14, and 15. It will order the power. That has 13, 14, and 15. Next para. As far as the provisions of section 13, 14, 15 are concerned, the same have been discussed by Honorable Supreme Court in the case of Delhi administration versus Ram Singh, reported in 1961, SCC online, SC 96. The paragraphs 13, 14, 15, 16, 19, 20, and 23 being relevant are relied on in this case, and the same are provided herein below. 13, 14, 15, 16, 19, and 20. 20 and 23. 19, 20, and 23. Next para. From the perusal of the aforesaid paragraphs as mentioned above, this it is clear that it is clear that in terms of section 13 of the Act, there has to be for a specified area, a special police officer appointed by or on behalf of the state government for dealing with offenses under the Act in that particular area. It is also seen that the special police officer is a police officer and is always of the rank higher than the sub-inspector.
Inspector of police.
Hmm?
Inspector higher than the, not below than inspector of police. 13(2), Lordship.
One second. Yes, yes, that special officer has to be, mm, mm, has to be an officer not below the rank of an inspector of police. So, Mr. Sharma, in your case, the advisory board is there, it looks
Yes,
like.
yes.
Their
looks like-
committee is
yes,
there.
Yes.
So, in terms of section 13, committee is there, but like
Committee.
nobody is like, I mean, we don't have any material to show
Material
that
to
somebody.
show under the act,
Under X,
Yes.
somebody has been specified.
Yes.
Committee is there.
committee is there for trafficking purpose, that is there.
From the provisions, as has been discussed by the Honorable Supreme Court, it is quite clear that though search without though the powers of search without warrant and arrest are given under the act, under the aforesaid Act of 1956, the same has to be done by a police officer who is specifically who is a special officer in terms of the aforesaid Act 1956. It is also seen that under section 2I, 2 Roman I, 2 Roman I, the comma, special police officer has been defined, which provides that special police officer means a police officer appointed by or on behalf of the state government to be in charge of police duties within a specified area for the purpose of this act. Next para. In the instant case, as mentioned above, an order dated 21/2/2026 has been issued by the Senior Superintendent of Police, Jorhat, has been provided, has been submitted before this court. Full stop. The aforesaid order provides that in pursuance of SIG, S capital IG, SIG and NO, number, NO means number, NO, CID capital, X 16, the CID, it should be 16, matlab Roman 16, Roman X and 5. You take it from here. Stroke, you take the number from here, dated, and this one, dated 28/1/2026 of the Senior Superintendent of Police, in bracket AHT capital, CID, Assam, Ulubari, Gauhati, the anti-human trafficking unit of the Jorhat district was reconstituted with the following officers and men, wherein Sri Abhishek Kumar Yadav, IPS, Additional Superintendent of Police, in bracket crime, Jorhat, has been made in charge of the unit. It was mentioned that they will function as coherent unit and will be integrated task force to prevent and combat trafficking in persons. It was also stated that the committee will tackle all the aspect of crime of human trafficking, that is prevention, detection, rescue, rehabilitation, reintegration, etc. And the committee shall be responsible for various for the following aspects. Semicolon. They shall conduct rescue operation whenever they receive information about trafficking activities. Then in bullet points, they shall handle victim with utmost sensitivity and provide best possible care after rescue and inform all the stakeholders. Unit of unit of AHTU shall collect information on traffickers and trafficking gangs, etc. Then next bullet point, child migration register to be opened at each police station to be monitored regularly. Then next point, in any trafficking related incident, case shall be taken over by AHTU of the district after pre-steps taken by Thana concerned with order from undersigned. Next, anti-human trafficking unit shall collaborate with the child line -1098 service in quotation. You take it from here after just, and the NGOs for mutual help and assistance. Next point, anti-human trafficking unit shall collaborate with NGOs, CLGs, common citizen, etc. to identify and monitor the vulnerable groups. Then next, they shall look into child labor and exploitation related issues. On perusal of the aforesaid order, it is seen that a committee has been formed. A committee has been formed under the leadership of Abhishek Kumar Yadav, IPS, the Additional Superintendent of Police, in bracket crime, Jorhat, to do certain activities. However, from the aforesaid order, it is not seen as to whether any police officer has been specifically named and notified in terms of section 13 of the immoral traffic Prevention Act 1956. 1956. It is a settled law that when, next paragraph, it is a settled law that when an arrest is made under, when an arrest is made under, arrest is made under any act, under any statute, comma, the arrest has to be made in terms of the BNSS 2023, if, if not specifically excluded. Section 62 of from the, then you write, from the aforesaid, from the discussion made by the Honorable Supreme Court in the aforesaid paragraphs, it is clear that it is clear that that last line, what was written? It is clear that then CRPC, BNSS, I have written something. No, write that content line. It is settled law, that line you cut. That line you cut. Till BNSS you cut. From the aforesaid paragraphs, that Honorable Supreme Court has observed that various provisions of the Act 1956 is a complete code with respect to what is to be done under it. It is seen that done under it, then right, it deals with the suppression of immoral traffic in women and girls, a matter which has to be tackled with consideration, intelligence and understanding of the problem. section, section clause B of subsection 3 of section 13 provides for association of a non-official advisory body consisting of not more than 5 leading social welfare workers of that area. I cut that and don't require, don't write it. You remove this. Then you write, the Honorable Supreme Court has also observed that the Act creates new offences, provides for the forum before which they would be tried and the orders to be passed on conviction of the offenders. Full stop. Necessary provisions of Code of Criminal Procedure have been adopted fully or with modifications. The Act provides the necessary machinery to deal with the offences created and its necessary implication must be that new machinery is to deal with those offences in accordance with the provisions of the Special Act, and when there is no specific provision in such Act, in accordance with the general procedure, and that no other machinery is to deal with those offences. It does not appear reasonable that the investigation of offences would have been left unprovided and was to be done by the regular police, in accordance with the regular procedure laid down under the code. Therefore, it is clear that since the aforesaid Act of 1956 provides for separate provisions of conducting investigation by appointing a special police officer in terms of the section 13. The investigation in such cases involving the offences of immoral trafficking and other related issues has to be conducted by a special police officer and not by by a general police officer or police officer, full stop. In the instant case, it is seen, next para, in the instant case, it is seen that no police officer has been specifically appointed by the state government. This is because of the fact that no material has been brought on record to suggest any such appointment of special police officer for investigation under the aforesaid Act. Therefore, the raid and arrest made by the general police cannot be termed to have been made in terms of the aforesaid Act of 1956. Being so, the same violates the mandates of the provisions of the aforesaid Act 1956, resulting in the accused applicant, resulting in providing a right to the accused applicant to be enlarged on bail. Next, taking into account the aforesaid provisions of law as well as the principle laid down by the Honorable Supreme Court in the case of Delhi administration in bracket Supra, this court is of the considered view that the arrest of the accused applicant in the instant case has not been done by the police authorities in terms of section 13 of the aforesaid Act 1956, thereby making the whole arrest an illegal act. Full stop. Accordingly, since the arrest has become illegal, there is no right. Arrest has become illegal. The accused applicant gets an unfettered right to be released from jail immediately. Full stop. Accordingly, it is directed. Hence, it is directed that the accused applicant shall be released immediately from jail on furnishing of a bail bond of rupees 1 lakh with 2 sureties of like nature to the satisfaction of the which court? CGM Jorhat, subject to the following conditions. Number 1, the accused applicant shall cooperate with the investigation and make herself available as in when called for. Number 2, the accused applicant shall not try to induce, that paragraph is there, you just put it, induce and this thing. Then you write any other conditions you require.
She will not try to contact the rescued women.
And the accused applicant shall not try to get in touch with other persons arrested. Other persons arrested and rescued. The other persons arrested and victims rescued during until the completion of the trial. No, it cannot be. It may not be a trial also. Contact so and so to influence them. To influence them in any manner whatsoever. Then you write, in terms of the aforesaid directions, the instant bail application is disposed.
Also, can the bail amount be a little bit less? Also, can the bail amount?
Bail amount 1 lakh.
It can be a little bit.
I want to increase this. If you say they decrease, then I'll put it 2 lakh.
Lordship,
Huh?
let it be.
2 lakh.
Let it be.
I'll make it 2 lakh.
No, 1 lakh.
No, 2 lakh is fine, but she's involved in so many illegal, immoral things.
Lordship, 1 lakh will.
I'll put it 2 lakh. No.
1 lakh will be sufficient. Lordship.
No, I'll put it 2 lakh. 2 lakh with 2 securities. I'll put one government this thing also. Right?
Lordship.
No, keep 1 lakh only. Mr. Chaudhary, when you get something, then don't ask for more.
Lordship. Oblige.
When voluntarily something has been given to you, don't ask for more.
Oblige.
$22.
May I please, Lordship? Lordship, the offenses involved in this it's a petty and minor offense, Lordship. And Lordship is aware that there is a existing circular of the state government to withdraw the petty offenses case, which is punishable up to 3 years. So my humble submission before Lordship, state may make their stand clear whether they will.
State where?
The state may make their stand clear whether they will withdraw or not after getting their position clear. I will put it as per merits, Lordship.
No, I didn't get it. What position they should make clear?
Lordship, as per the existing government circular, Lordship.
What is your case?
Yes, Lordship, government circular. Lordship, kindly come to page 17. Search it. Here the offense Lordship labeled against me 353-294-427-34 IPC read with section 51B Disaster Management Act. And all are Lordship below 2 years maximum punishment. And this case has been pending since last 4 years, Lordship.
Yes.
Hello, I am came for the respondent number 2, my lord.
No, are you ready?
My lord, LCR perhaps, my lord, required in this case, my lord. LCR is not there.
Perhaps was on 39/2022. It is written in our petition on the notice issue, then further proceeding state and records were called for. Whether called for or not, because the record as per cause list, there is no record. Record has not come.
Otherwise, my lord, search it, file against the petitioner, my lord.
Case report is not received as per the official note.
Then my lord, reminder, my lord.
But he's saying the petty offenses and I mean,
Lordship, kindly have a look this
the office circular is there.
circular.
Show me the, give me the office circular.
Let them try before the court below, my lord. That notification, my lord.
So let's see what is the office.
Yes, my lord.
Where?
Second page, Lordship.
Second page, the third page,
Second page, Lordship.
second page, yes.
The Government of Assam by notification so and so, dated so and so has constituted a committee to be headed by the principal secretary to the Government of Assam.
Where are you reading? I didn't get it. Which paragraph you are reading?
Paragraph, second page, Lordship.
Second page, the bottom paragraph.
Lordship.
Accordingly, Government of Assam. Where are you reading?
Second page of the documents, my lord.
Huh?
Not the.
You are reading this or not? This
Yes,
document?
yes, Lordship, I am
The
reading.
which paragraph? And which page?
Here, pagination is not there, Lordship, but from the notification to next page, Lordship. Notification dated this for 21st.
Then next page is objective behind the legislative policy, litigation policy. Correct? On the top of it. Some other document you are holding on. There is some other document.
Second.
This is a different document over.
I think pagination, I think there is some misplacing of paper.
These are both sides. These are all single sides.
Sorry. Center.
So you want your matter to be referred there? Or what? You have already been convicted.
No, Lordship,
Not
only,
convicted.
only.
Sorry. Charge sheet has been filed, yeah.
Charge
sheet has been filed.
Filed and cognizance taken.
Cognizance
That
is taken,
stage.
correct.
And after that stage, Lordship, I approach this honorable court and honorable court state the proceeding before the court.
Right.
And at
Now
that-
this official memorandum is there.
Lordship, as per that office memorandum, Lordship, actually, the PP concern of the court has to take necessary step for.
But the committee has to take, how this committee will take any action till the time you approach them.
So, Lordship, in this instruction, in this circular, there is no such instruction to approach by the.
Then how they are going to get to
So
know?
all the VPs across the state have been instructed through this.
Where is that? Where is that?
Instruction is there, Lordship.
You give him a copy first. Give him a copy.
This case is listed or not, we don't know. Matlab. So let the record come. Matlab. It is already state in on 30th of September 22.
The records will come, but you take instruction on this also, because he's saying that like there's a committee formed by the state government judicial department only. In petty cases, I mean, which are pending for some time, those cases, I mean, can be resolved, it can be resolved. So I mean, a committee is there, the committee will advise. So you take on, you give him a copy also.
I will surely provide copy.
You give him a copy of this, so he will take instructions on that also. Okay? Understood?
Lordship, I understood.
You give him a copy of this so that he can take instructions also. And in the meantime, we have not received the CD, sorry, that TCR. So let the TCR come. Your name?
A Islam.
I heard Mr. A Islam, the learned counsel, appearing for the petitioner. Also heard Mr. K. Parasar, the learned APP for the state, and Mr. K. Kalita, the learned counsel, appearing for respondent number 2. TCR in the instant case hasn't been received. Let the matter be listed in the first week of August. First week of August. And you give me a copy so that he can take instruction.
Interim may continue, Lordship. Interim order may continue.
Interim order so passed shall continue till the next day.
Still, Lordship, this is their order. I have obtained from.
Understood, but he doesn't have a copy. Give him a ready copy so that he can take some instructions. Otherwise, how he will refer to?
May I please, your lordship? My lord, this is a 482 CRPC quashing petition, my lord. I am paying for quashing of the FIR, the charge sheet, the order of cognizance, and the PRC case that has been registered and currently under trial, my lord.
TCR is received.
Yes, my lord.
TCR.
My lord, the FIR has been lodged. May I submit, my lord?
Your name?
A Khan, my lord. My lord, the FIR has been lodged by the wife against the husband as accused number 1. He is before your lordship as the petitioner. There are 4 other accused persons were there in the named FIR. The mother-in-law, brother-in-law, and 2 sisters-in-law, my lord. My lord, the allegation is of demand of dowry and specific allegation against the brother-in-law that he tried to disrobe her. And accordingly, 354B was also included in the FIR, along with 498A. And it was read with section 3 and 4 of the Dowry Prohibition Act, my lord. My lord, the written Ezahar, typed copy of the written Ezahar, my lord will find it, page number 15. Page number 15 is the typed and translated copy of the written Ezahar that was submitted by the wife. And my lord, the specific allegation is that demand of dowry of amount of 5 lakhs and a car, and then physical and mental torture. And after the husband left for his workplace on 23rd of March, the marriage was conducted, my lord, but marriage was held on 9th of March 2023. Husband left for his workplace at Jammu and Kashmir. He's a CRPF personnel. And he left for his workplace on 23rd of March 2023. After that, it is the allegation that the brother-in-law tried to disrobe her, after which she got ill, she got admitted in the hospital, and then she lost an FIR on...
Who has demanded the money?
My lord?
Money has been demanded by whom?
Money was demanded by the family members, the husband, brother-in-law, and sisters-in-law, except the mother-in-law. That is the specific allegation. If I may read, my lord. My lord, the exact line was But the accused person being dissatisfied, the accused person except accused person number 2 demanded a sum of 5 lakh and a new car from my father as a condition stated by the accused person.
Okay, now what has happened after this?
My
After
lord,
the
my
FIR,
lord,
what
after
happened?
that investigation was conducted.
Hmm.
A formal FIR was registered. That formal FIR, my lord, will find it page number 17A. And after the charge sheet was submitted, investigation completed, charge sheet submitted.
Hmm.
My lord may kindly take the charge sheet at page number 25.
That's it.
Charge sheet at page number 25.
Hmm.
At point number 15, my lord,
Hmm.
charges are framed, charges are leveled only against the husband Ashutosh Dev. No charges against the relatives, the in-laws. And my lord, the report of the IO, very interesting, my lord, the findings of the IO. My lord, the typed copy, my lord will find it page number 29. 29 is the findings of the IO.
Ashutosh Dev is what, husband?
Husband, my lord.
Hmm.
Husband, my lord. Findings of the IO is at page number 29, the typed copy. And the
Where is the original?
vernacular at page number 29C, my lord.
29C.
29C. 29C. Now, my lord, the first page is the description of entire incident. The specific finding, my lord, will find it page number 30. 30, the new paragraph that starts, my lord. If my lord permits me to read line number 4 of the new paragraph, my lord.
One second.
Yes, my lord. Page number 30, my lord.
Page number 30, what?
Page number 33, the new paragraph that starts, my lord. Todonto kalor, that part, my lord. The fourth line, I will read the fourth line, my lord. May I read it, my lord? তদন্ত কালত সাক্ষীবাদীৰ জমাবন্দীত পদকীয়া সকল যৌতুক দাবী কৰা আৰু পদকীয়া স্বামী শ্ৰী আশুতোষ দেৱে গুচৰিয়ানীক শাৰীৰিক অত্যাচাৰ কৰা আৰু পদকীয়া শ্ৰী বিশু দেৱে গুচৰিয়ানীক কুপ্ৰস্তাৱ বা শাৰীৰিক অত্যাচাৰ কৰা সাক্ষীবাদীৰ জমাবন্দীত পোৱা নগল. Nothing from the statement of the witnesses. মোৰ অধিক তদন্ত কালত জানিব পৰা যায় যে গুচৰাণী আৰু পদকীয়া স্বামীৰ মাজত ফোনৰ যোগেদি কাজিয়া কৰা আৰু তেতিয়াৰ পৰা দুয়োৰে মাজত বিবাদ আৰম্ভ হয়. So my lord, it's a matrimonial dispute given the color of a criminal offense, my lord. Then my lord may kindly take line number 7th line from bottom, my lord, of the same page. On the right hand side, it starts, my lord. তদন্ত কালত গুচৰিয়ানী তথা ভিক্টিমৰ ডক্টৰী প্ৰতিবেদন সংগ্ৰহ কৰা হয় আৰু ডক্টৰী প্ৰতিবেদনত কোনো আঘাতৰ চিন প্ৰাপ্ত হোৱা নাই বুলি উল্লেখ কৰিছে. My lord, even the medical report has come, my lord, along with the TCR. Medical report is clean. Medical report states that there is no injury mark on the body of on the person of the victim, my lord.
Correct.
So, my lord, the charge sheet, in the charge sheet, there is nothing against the accused persons. Accused persons number 2, 3, 4, and 5, they have been given clean sheet. Only section 498A has been leveled against the current petition. Then, my lord, cognizance is taken, my lord. My lord will find the cognizance order at page number 42. Surprisingly, my lord, during the cognizance, all the sections are again added. 354B, how 354B will come against this petitioner? It was against the brother-in-law. A mechanical cognizance order, my lord. Page number 42, my lord. Cognizance has been taken against Ashutosh Dev under section 498A, IPC 354B, read with 3 and 4 of the Dowry Prohibition.
42.
Page number 42, my lord. That's the order of cognizance.
42 says cognizance therefore taken in the aforesaid person, aforesaid section.
Yes, my lord.
Cognizance. Okay.
On perusal, it transpires.
On perusal, transpires that prima facie under section 498A, IPC 354B, against the accused person only of Ashutosh
Dev. Now, my lord, the other.
So, no, Ashutosh Dev is the husband.
My lord.
for 498A, 354B, and 3 and 4.
3 and 4. 3 is payment and acceptance of dowry, and 4 is demand of dowry.
And 398, now what is the no,
354.
new sections?
But this was at the time of CRPC, my lord.
Now, what has happened to the lady?
My lord.
What has happened to the?
She is staying with her father now. She has also registered a domestic violence case against the husband.
But 498A B is there.
My lord.
498AB.
AB, my lord.
AB is what? AB is cruelty.
My lord.
So cruelty means what? Harassment of a woman.
My lord.
Harassment of the woman, where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security,
My lord.
or is on account of failure by her or any person related to her to meet such demand.
My lord.
So harassment angle is there. It's not only that physical cruelty has to be there and other things has to be there.
My lord,
So how do you say that 498A is not applicable?
My lord, 498A is mainly on dowry, my lord.
Yes, dowry.
Amount of dowry.
We have demanded dowry.
My lord, the statement of witnesses specifically say this.
No, FR specifically states that demand has been made.
My lord.
And this charge sheet has been filed accordingly.
My lord, in the charge sheet, there is specific statement that nothing could be found about dowry.
Over the phone, there are some harassment happened.
My lord, that's
Over the phone, certain harassment happened.
matrimonial dispute, my lord, 20-year-old.
Matrimonial dispute because of dowry demand.
No, my lord. My lord will kindly consider, my lord. My lord, if I may just place a judgment on this, my lord.
Forget about judgment. First, place the facts properly.
My lord, only the FIR will not
You show me the documents from where you are saying that there is no harassment, nothing. You are only showing that,
Yes,
showing
my
the
lord.
police officer's report.
My
Police officer's report says there may be some telephonic phone calls. Telephonic phone calls, there may be harassment. You call her and say that bring this money, bring this money. Is it not harassment?
My lord, he left for his workplace just to the
So
18
what? He left for the place. That's why he has used the work phone, again, mobile phone. Otherwise, he would have personally told her.
My lord, if my lord, you kindly take the statement of the witnesses, what they say, my lord. Statement of the witnesses is
Which
very clear,
witness?
my lord.
Which witness?
The witnesses that has been produced by the prosecution, my lord. The witness of the prosecution that has been relied upon. The TCR has come, my lord.
183 statement.
Yes, earlier it was 161.
161 statement.
My lord. That is specifically stated that there was no demand of dowry. Never. They were living happily. Specific statements are, if my lord may kindly take it, my lord.
They were living happily.
Yes.
Who said so? The person concerned who suffered, she is saying that she is being harassed, and some independent people are saying. Yes.
My lord.
Some independent people are saying she is in the hospital.
My lord, the statement of.
One
the
second, one second.
Kulsuma Bibi, my lord. Kulsuma Bibi has stated, Gosoriani or dies, may I read, my lord?
No, I mean, you read something from the report, right?
My lord, from the,
And some portions you didn't read.
my lord,
So, so I'll just read one line.
my lord.
Um, mm, See, it is, I'll just read one line. কিন্তু ইমান নং পদকীয়ানীয়ে তেওঁৰ আত্মীয়ৰ সৈতে কুচক্ৰান্ত কৰি যৌতুক নে কি লিখিছে I cannot read this. পিতৃৰ পৰা যৌতুক হিচাপে 5 লাখ টকা ও এখন নতুন something বিচাৰে।
নতুন গাড়ী।
হা?
It might be a car.
পদকীয়ানীৰ পিতৃয়ে উপায়হীন হৈ 1 নং পদকীয়ানীৰ হাতত 5 লাখ টকা তুলি দিয়ে আৰু অন্য দাবী পাছলৈ পূৰণৰ চেষ্টা কৰিম বুলি কয়।
That's the facts of the case.
পদকীয়ানীক শাৰীৰিক আৰু মানসিক অত্যাচাৰ আৰু তেওঁলোক বিবাহ সম্পৰ্কত সন্তুষ্ট নহয়। There are a lot of allegations.
My lord, charge sheet has been submitted. Once charge sheet has been submitted, my lord, it cannot be only on the FIR, my lord. My lord, kindly take the judgment for one moment, my lord.
This is not FIR I am reading.
My lord, that's the facts that has been pinned down by the IO. And later on, he has given his investigation report, my lord, what he has found in his investigation.
What is this?
My lord, this is a judgment of the.
I'm not asking for a judgment now. I have to be clear about the facts. I'm telling you time and again. And you are just giving me a judgment without knowing the facts.
My lord, regarding.
Do you think that I have read the whole thing? I marked up everything. Everything is in my head. Let me first be clear about the facts. Then you give me the judgment.
My lord.
I have told you that let me be clear about the facts. You may be clear with your facts, all details, but this court may not be all the time.
I apologize, my lord.
I cannot read all the cases and all the facts. So you'll have to give me some time. And without knowing the facts, you are giving me a judgment. How will I apply the judgment if I do not know the facts? Is it possible? Without knowing the facts, I'll apply the judgment. What judgment you are giving me?
Lord, this judgment.
No, what judgment you are giving me?
My lord.
What judgment you are giving me?
My lord, on the point that if the co-accused, the family members are released, then the offense against the husband, it has to be set aside. The proceeding against the husband should be set aside.
When the co-accused have been released, the proceeding against the husband has to be set aside.
Because
against the husband has to be set aside
because it is a matrimonial dispute.
Yes.
That has been given the color of a crime.
Who is saying so?
My lord.
Who has come to a finding to that?
My lord, the honor.
No, whether on these facts that finding has come, it has been given a color of crime.
My lord,
has trial been completed?
No, my lord.
Then first you have to convince this court that color has been given. Court has to be convinced. You can only argue a matter. You cannot just say that like it has happened like this. It has gone like this. I mean, let me read first.
Yes, my lord.
A drop of the hat, you will just give me this judgment if this is judgment. First of all, let us understand what is happening in the case. And if you think that like, you are prepared and like in 1 minute I should dispose of the case, then you go to a different bench. You go to a different bench. I'm not hearing this.
Definitely not.
You go to different bench.
My lord.
We'll place it before.
I vote on my lord. My lord. Definitely not.
Place it before different bench.
My lord.
If you think that like 1 minute I should dispose of this case, you go to a different bench.
My lord. I vote on my lord.
Adjourn the matter and list it in the month of August. Go to appropriate bench.
My lord,
adjourn the matter and list the matter in the month of August, first week of August, second week of August.
I had no intention to.
No. I mean, this is not the way to do it. Go to a different mess. First, I mean, we are not understanding the case at all. What is happening? We are on the FIR, and then you started giving me case laws.
My lord.
You may have read 1 month. I don't have time to read the whole, only your case. 70 cases are listed here. We go in the month of August, it will come. Next case. Apply. Yes.
Lordship, the European order is at page number 39, Your Lordship. 39, Your Lordship. Your Lordship, it's a quashing petition, Your Lordship.
Yes, question.
Lordship.
Question against?
Against this order, Your Lordship, page number 39, it was passed by Executive Magistrate, Your Lordship. Here, Your Lordship, the fact is that, Your Lordship, the petitioner and there's a private dispute, Your Lordship, regarding a land, Your Lordship, in between the petitioner and the respondent number 1, Your Lordship. But, Your Lordship, the Executive Magistrate.
Anybody is appearing for respondent?
Name has been.
In the last occasion also, they don't appear. Your Lordship.
Yes. Name is there.
Some R. Goswami and Devi is there, Your Lordship.
R. Goswami and Devi. Name has been shown, my lord.
Who? R. Goswami?
And Devi. PCI is not available.
PCI call for no.
No, also.
They are the main party, matlab, state
Main party.
or only formal party. Matlab.
So we'll put it some other day,
Lordship, Lordship.
some short date or something. When do you want?
We stays there, Your Lordship. Already stayed, Your Lordship.
Stay is there.
Yes, Lordship.
So we'll put it in the first, sometime in the August.
Lordship, as per the convenience.
Heard Mr. MS G. Bora, the learned counsel appearing for the petitioner. Also heard Mr. K. No, they're right like this. MS G. Bora is present for the petitioner. Mr. K. Parasar is the learned APP is present for the state. However, none appeared for respondent number 1 when the matter was called. But last time also she was not there. Okay, matter was called for. Let the matter be listed in the second week of August on a date to be fixed by the registry.
29.
My lord, earlier occasion, my lord, I sought time, my lord, for I am appearing as a central government counsel. Well, subsequently, what happened, my lord, I have sent the 2025 case, my lord, I have sent the whole documents and all this by speed post. Their departments, they have shifted the my lord, office. Because of that, they didn't get it. Subsequently, I again sent the email on 17 June, my lord. Now, my lord, last week they have contacted with me, my lord. They have seen some time, my lord. They already matter is stayed, my lord.
Okay, nobody is there also.
And
None appeared for the petitioner when the matter was called for. Though Mr. K. Parasar, the learned CGC, is present. For the interest of justice, let the matter be listed in the third week of August.
Party.
It please, Your Lordship. Your Lordship, this is a jail appeal. Conviction is under section 10 POCSO. Your Lordship.
You are appearing as a?
Legal aid counsel.
So we'll issue notice on this.
Yes, Your Lordship, and the appeal may be admitted, Your Lordship.
You are appearing or what?
No, Your Lordship. No, next case. Not in this case, ma'am.
heard Mr. M.K. Brown, Ms. M.K. Brown, the learned legal aid counsel, appearing for the accused, appearing for the appellant. The instant appeal has been filed under section 415 bracket 2 of BNSS 2023, read with section 528 of 528 thereof, filed against the order dated 30/4/2026 passed by the London Special Judge POCSO Gulaghat in special POCSO case number 19/2022, convicting the appellant under section 10 of POCSO Act 2012 and sentencing him to undergo rigorous imprisonment for 5 years and also to pay a fine of rupees 10,000 in default, SI for another 6 months, and under section 323 IPC sentencing him to undergo SI for 6 months. Will issue notice to respondent number 2.
Yes, Your Lordship, the TCR also may be called.
TCR will call for. Issue notice to the respondents. No formal notice is required to be sent to respondent number 1 since Mr. K.K. Parasar, London APP puts in his appearance. Then notice to respondent number 2 as per the prevailing notification issued by the Gauhati High Court. Call for the TCR in connection with special POCSO case number 19/2022 from the court of the
Special Judge.
Learned Special Judge in bracket POCSO Gulaghat.
Since it is a JLP will paper book will be necessary.
Paper book will come after that only.
After that, after the
let it come.
Let
TCR come. TCR comes, then we'll pass an order.
Obliged.
Lordship, I'm very sorry that item number 29. Item number 29. I was legs before number 6.
It's just earlier order.
Just earlier order.
I am the appear the CC.
Okay, you will put your name.
Yes, and
Mr. So and so for
M. Sharma.
N. Sharma for the petition. Okay, we have put it. We put it. He's seeking some time.
Third week of August.
Third week of August.
Your Lordship, that means,
Interim order is there. Okay, interim order so passed earlier. So I'll continue till the next day.
Lordship, this is a criminal appeal against conviction order dated 14/5/2026, where the appellant was convicted under section 305 part 1 of IPC and whereby sentenced him to 10 years of imprisonment by learned additional session judge Gulaghat. Kindly Lordship, the appeal may be admitted and TCR may be called, Lordship.
I fell for a
Yes, territorial appeal. We can admit this.
Will be admitted.
Heard.
Lordship M. Bhuya.
Huh?
Lordship M.
Heard MSM Bhuya, the learned counsel appearing for the appellant. Also heard Mr. K.K. Parasar, learned APB for the state. This is an application under section 415 bracket 2 of BNSS 2023, assailing the judgment of conviction dated 14/5/2026 and order of sentence dated 16/5/2026 passed by the learned additional session judge Gulaghat, Assam in sessions case number 24/2021, convicting the appellant under section 304 part 1 of the Indian Penal Code and sentenced to rigorous imprisonment for a period of 10 years and a fine of rupees 50,000, in default of payment of a fine and to suffer simple imprisonment for a period of 3 months for offense under section 304 part 1 of IPC. Appeal, admit the appeal. Call for the TCR. Call for the TCR in connection with sessions case number 24/2021 from the court of the learned additional session judge Gulaghat. Let the matter be listed after 3 weeks.
Conservative Council P. Mohanpal Lordship is not feeling well, Lordship.
Okay. Um, uh, Parties are duly represented. Let the matter be listed in the third week of August on a date to be fixed by the registrar.
Lordship, interim may continue.
Interim orders of passed earlier shall continue till the next date of listing.
Obligement.
Matter Lordship pertains to passing of.
We won't be able to take up this matter today.
Well, Lordship may fix it. Can it be next week, Lordship, any day, Lordship, on 27 or 28? Because the date in the lower court is fixed on 5th.
Parties are duly,
The lower court date is fixed on 5th of.
5th of August.
Yes, Lordship.
Parties are duly represented.
I'm praying for 27.
Let the matter be listed on 28th. Let the matter be listed on 28th. For admission, no?
Admission.
For admission. Hearing. For admission.
Obligement.
65 orders.
None appeared for the petitioner when the matter was called for, though Mr. K. Parasar is present for the state. And appeared for the state, let the matter be listed after 3 weeks.
Next case.
Yes.
I have filed an interlocutory application in this. For vacating the order of stay granted on 10th of March 2026.
It will require some hearing. I mean, we'll take it up some other time, not today.
I have some urgency. I'm okay, my lord. I'll refer because this is order by the stay order, my lord. The interim maintenance granted to the wife and the 5 years old daughter has been stayed.
So, I mean, I understand, but the thing is that it will take some substantial hearing because stay has been granted after hearing the matter, right?
No, my lord, not after hearing the matter, my lord. On the first day stay was granted. We are not
Stay was granted, so vacation of the stay, I mean, whatever, the one court has granted a stay, so vacating that will require some kind of hearing.
May I pray for some short date, my lord,
Okay, I mean, we'll put it on sometime around 27, 28.
of this month, my lord. Yes, my lord.
The right parties are duly represented. Let the matter be listed on
28, my lord.
28.
July.
Let the matter be listed on 28.
Deeply obliged.
Interim orders of past earlier shall continue. Huh?
My lord, can it be on 29th? 29th, my lord.
Then let it be on Thursday, my lord. For hearing day, I will prefer, my lord.
Okay, 30th then?
Yes, my lord.
Huh?
Yes.
Let it be listed on 30th of this thing, 30th of July.
Yes, my lord. 38th of July.
Obliged.
Obliged.
69.
Yes, please, Lordship. Lordship, the informant is appeared, Lordship.
Survey report is awaited.
The Lordship, informant
Yes,
is
I have appeared.
Oh, you are appearing.
appeared.
You are appearing for respondent number 2.
Yes,
Sorry, I filed a column.
You filed a Wakaran. So we'll put it up in the first week of August.
Lordship, last
This is a
week of-
bail application, okay.
Bail application, Lordship. Investigation is completed, charge sheeted cases, the Lordship, during the investigation, he has already recorded his.
Charge sheet
Charge sheet
is
cases.
TCR has come.
This year's not come, Lordship.
Then
Only medical report was called, that report was not in the record that reflected it.
I have necessary objections for this bail application, Your Lordship. Let it come in next.
okay, we'll put it up in sometime in the on 29, 27, 27th. 27th will be earliest
Issue
27th.
reminder for TCR, Lordship.
The TCR is not called for probably earlier.
Lordship then.
PCR is not called for, actually, the medical.
So if charge sheet is filed, TCR will be required.
Required.
The statement of the victim is required.
And TCR will not come, may not come in such a short duration.
Lordship, Kamrup Metropolitan.
Okay. Heard Mr. SRA
Nasir.
Nasir, the learned counsel appearing for the accused applicant. Also heard Mr. DP Goswami, the learned APE for the state, as well as Mr. J. Roy for the respondent number 2. TCR in the instant case, the registry to call for the TCR in connection with session special case number 117/2025 including the medical report or scan copies, including the medical report. Medical report from the court of the learned special judge, Pakso, Kamrup Metro. Let the matter be fixed on,
27 Lordship.
what was the agreed date? 27. 27.
Leave clause.
Okay.